tagad angļu kanālā tikpat labi runājam, tikpat skaisti viss skan. Angļu kanālā. Pārbaudam angļu kanālu. Vai viss labi?
Var pamēģināt. Šis ir angļu valodas kanāls. Kanāls numur 1, angļu valoda, kanāls numur 1, angļu valoda, kanāls numur 1. Nezinu, turpināt man kaut ko runāt vai nē. Pārbauda, nepārbauda, nevar saprast, jau nesaka, nereaģēt.
Laukā un atkal pie
highly esteemed President of Latvia, dear colleagues, you are welcome at the capital of Latvia, Riga, at the international conference organized by the Constitutional Court, Sustainability as a Constitutional Value, Future Challenges. We are going to open the conference by honoring the anthem of the state of Latvia. Please rise. Dear participants of the conference, I am honored to welcome you on behalf of the entire Constitutional Court of Latvia, the members of the conference Sustainability as a Constitutional Value, Future Challenges. By this topic chosen by the conference, we are honoring those values that intertwine the basic law of the Republic of Latvia, Satversme, the Constitution, in the 100 years of its existence. The organizer of the conference, the Constitutional Court, has been safeguarding these values for more than a quarter of a century. The name included in the title of the conference, Sustainability, is not only a topic that has been highlighted quite often, and we can discuss it meaningfully over the course of 2 days. First of all, it's a fundamental constitutional value which has been particularly highlighted in the text of our Constitution, namely, each individual takes care of oneself, one's relatives, and the common good of society by acting responsibly towards others, other people, future generations, the environment, and nature. Dear colleagues, the Constitutional Court, in several its rulings, has underscored that the principle of sustainability has been one of the founding principles for the state. Democracy, sustainability, human dignity, and protection of human rights are mutually reinforcing values. Sustainable development for everyone is linked with stability, foreseeability, and safety. And yet, this international conference today is held at a time when situation in the world, in Europe and Latvia, cannot always be characterized by using these words that I just mentioned. Due to war in Ukraine, general energy crisis, and also the problems in managing COVID pandemics, We are facing unprecedented challenges in many areas. And the Constitutional Court, in getting ready for this conference, over a longer period of time, encountered new dimensions of the issues advanced for discussions, and also threats to democracy, fundamental rights, and environmental sustainability. To find the possible solutions for such challenges to sustainability, we have advanced three matters that will be discussed during these 2 days in three panel discussions. And during these panel discussions, we will listen to presentations given by renowned practitioners of law and legal scholars. During the first discussion of today, sustainability of democracy, we are asking the question how to prevent threats to democracy in a democratic way. And we will underscore the role of constitutional courts in ensuring balance between the protection of fundamental rights and the need to decrease or eliminate various threats to democracy. The issues that will be discussed during the panel discussion is very extensive, especially at the time when we are encountering challenges to freedom of expression, electoral rights, dissemination of fake news, and misleading of society. More and more global leaders and other influential figures are calling upon to look at the conditions in which democratic orders are functioning in the world. And they recognize that we have lived for a long time being convinced that democracy is guaranteed forever, but it's not the case. As is well known, democracy is impossible outside a state. Therefore, existence of the state itself is one of the values in a democratic state governed by the rule of law. This state has obligation to use all legal means to ensure its existence and to prevent threats to its existence. We have to recognize that creates a certain vicious circle, namely, a threat to democracy can be prevented only in a democratic and legal way. However, turning against democracy often is implemented by using the means and the measures provided by a democratic state governed by the rule of law. To break out of this vicious circle, dear colleagues, we cannot allow that democracy is functioning only in a way that one group of society accepts it only when the solution, opinion, or regulation that it prefers is dominating. Democracy must be defended, and we all have to stand for it. And this is not the task only for the legislator or the government. With exclusive competence, the courts have been given exclusive jurisdiction, extensive range of tools for protecting democracy. The main risk in governing modern democratic state governed by the rule of law is law. And that's why the courts have a very important role in implementing those directions of development of the state and society by applying law. The constitutional and supreme courts of European countries, the representatives of which have gathered in this conference, especially in the current conditions when democracy is under threat, are of principal importance. The rulings of these courts contain the most important legal findings that develop the legal systems of our states and creates the tomorrow for the whole Europe and the world. At the same time, I would like to underline that for a longer period of time, the institutions of judicial power have been functioning in conditions of various crises and challenges. Of course, in times of crisis, it's important to adopt decisions swiftly, often following the precautionary principle, not waiting for negative consequences. In such changing conditions difficult to predict, it's quite complicated to work, but the courts should be courageous and should be ready to adopt complex decisions to ensure protection of democracy in the long term. Highly esteemed audience. Exercise of fundamental rights included in constitutions and protection of the rights is the supreme aim of all democratic states governed by the rule of law. That's why during the second panel discussion of today, entitled Sustainability of Fundamental Rights, Adapting Fundamental Rights to the Age of Modern Technology, we will turn to such questions whether already now we should not take a wider view on the scope of fundamental rights in digital environment. And there's a reason for it. Protection of fundamental rights in the ordinary understanding of it in the internet environment faces unprecedented challenges related to inviolability of private life, data protection, freedom of expression, and remote assembly. Lately, we have observed also certain collision between different conceptual views on creation of the system of legal norms and also creation of legal acts at the time when technologies are developing so swiftly. On the one hand, we have this flood of provisions trying to keep up with all nuances in the development of modern technologies, creating very detailed new legal norms. On the other hand, to ensure sustainability of the regulation on technologies, the legislator, in developing legal norms in the area of technologies, can also apply the principle of technological neutrality. Legal norms which have been drafted and adopted in accordance with this principle contain general concepts and terms which characterize the technologies that have to be regulated depending on the aim of their use, impact, functions, and other features. By this way, it would be possible to create the legal infrastructure that would comprehensively and smartly serve the ongoing progress, forecasting the necessary legal consequences. Therefore, during this panel discussion, we will attempt to establish whether a new constitutional or supranational regulation should be drafted, or whether it's possible to apply the existing regulation or to create a laconic or neutral legal construction and interpret them in a dynamic way. Dear colleagues, presently, such development of national politics complies with a model of sustainable development which balances the need to promote economic growth and to improve the quality of the living standard for each member of society, as well as the need to safeguard natural environment for the coming generations. That's why the concluding panel discussion of the conference, entitled Environmental Sustainability, and again we are putting the question, a political choice or a matter of fundamental rights. Tomorrow, during this panel discussion, the participants of the conference will analyze whether the measures taken by different nation states have been sufficient to prevent climate change, and whether a person has the fundamental right to require the state to take the necessary measures to ensure sustainability of environment. Similar legal issues have been relevant in several cases already now on the agenda of the European Court of Human Rights. So also in ensuring sustainability of environment, courts play a very important role. And during this panel discussion, we will listen to opinions of the members of the conference, also with respect to the limits of court's jurisdiction in this area of law. But I also believe that it's important to underline already for 6 months now, after Russian Federation has launched war against one of the European countries, Ukraine, the representatives of its constitutional court have honored us with a presence. Geopolitical conditions also with respect to environmental sustainability have changed. And I believe we have entered this new global order only partially prepared for it. For example, in the conditions of energy crisis, our possibilities to use renewable energy sources are not used in sufficient scope. So we see that some of the issues of environmental sustainability meet new challenges. European countries are getting ready for the coming winter by storing fossil fuel, and quite recently the plans were to gradually give up using it. And the courts should be able to see this special context, reaching balance between long-term progress towards environmentally friendly energy on the one hand, and on the other hand, the need to guarantee living conditions worthy of human dignity during crisis of energy resources. Although during this largest military crisis in Europe after the Second World War, increasing prices of energy resources, goods and services should be seen as material deprivation, but this cannot turn into diminishing of democracy or disproportional restriction of human freedoms. I underscore, we have to understand that these inconveniences in the European Union regarding payment of the bills cannot be compared to the situation where Ukrainians are fighting for the democratic values of the entire Europe and freedom, and they are losing people close to them. Hoping that the victory will come soon, I would like to remind that Latvia has suffered from the same aggressive enemy. Our backbone of our the backbone of our statehood have been our strong people and our constitution. The values included in it have guided the people of Latvia through dark events and allowed to celebrate the existence of a free and independent state. By overcoming all these difficulties, we can clearly state that our constitution, as a modern constitution which is not getting outdated in its year of its centenary, encourages us to think about today and about the future, appealing to us to act in a way to promote the sustainability of the state of Latvia and the world. Dear colleagues, I wish to all participants of the conference and also the audience following us remotely to find high-quality findings and appreciate this wonderful possibility that we can meet face-to-face and discuss about those legal issues which are important for Latvia and for other countries of the world. Thank you.
And now it's my honor to give the floor to the President of the Republic of Latvia, Mr. Egils Levits. Please, Mr. President, the floor is yours. Honorable President of the Constitutional Court, dear participants, let me today focus on fundamental rights in the digital environment domain and whether we need a new constitutional regulation with regard to this part of the technological progress. Let me start by highlighting some of the challenges. And instead of picking particular challenges and their social impact, I would like to rather focus on the overarching problem, the question of free will and how free will is covered by constitutional and other rights. I will start with this introduction, and then I will focus on how technological progress has influenced and will continue to influence democratic processes in democracies, in our political system. And thirdly, I would like to address the role of, or the importance of constitutional rights or constitutional framework in averting the potential threats to our democracies. Let me start, first of all, with the introduction. Our legal system, since it was created 3 centuries ago, during the era of enlightenment, has been based on one fundamental value of personal freedom. It is the very founding block of our legal system. Without it, anything that we are talking about here about the accountability and the engagement or participation does not matter. It's all based around free will that human beings possess. So that's the fundamental building block. We cannot, as individuals, predict how we will act in particular circumstances, and nobody else can predict our actions in particular contexts. So the philosophy and the concepts of the Renaissance are based on a sort of a black box theory. You don't really know what you have inside of you, and this has been researched by the liberal Canadian philosopher Taylor in one of his studies, the sources of self. At the end of the day, we don't know how our actions will be determined by political circumstances or contexts, but that's the basic block, the fundamental block. However, now the digital progress has opened numerous opportunities ahead of us, also allowing us to predict how humans will act. And as soon as you can predict how humans will act, you can also influence or manipulate their actions, which can be achieved by building a surveillance infrastructure, if you will, spy web, which controls individual data, which is then processed to manipulate people. So what kind of a framework am I talking about when I'm talking about the spy web that has been created as a result of digital advancement? Well, it is basically a process which consists of several steps. In the phase one collects data, and every minute, every second we produce data and we give up our personal data. Our conversations, our text messages are being recorded. Emails can also be traced. And lately also various health applications that for example, collect our heart rate, monitor data, and so on and so forth, can be accessed, and our internet search results are also available if you know where to look for them. And you just can tap into a mobile phone, any smart device, but you can also use a smarter ways to monitor communication in the digital domain. Then the data that is collected is being integrated, fed into big data software. Big data is all about the size or the amount of data available on each particular individual. So it is enormous amount of personal data that is quickly collected, aggregated, integrated, and you can aggregate data from various sources, and that allows you to conduct phase 3, or the profiling of an individual or a person. So any one of us, based on big data, can be very precisely or relatively precisely profiled. This profile indicates a lot of information about your life, various aspects of your personal life, which makes you incredibly predictable. If you constantly monitor somebody, you can fully predict how this person is going to act in particular circumstances. And this predictability puts us in an entirely new situation, which basically undermines the main assumption that we'd been operating on the basis of for the past 3 centuries, that we all possess a free will as individuals, as human beings. So from a philosophical point of view, from an academic point of view, this means that there are a lot of questions. What does this lead to? Maybe a free will is just a philosophical notion, just a philosophical concept that we have all accepted for quite a long time. And some philosophers also recognize this. Some of the computer scientists also recognize this. And let me quote to you, American behavioral psychology leader, Mr. Skinner, has said the following, let me quote: personal autonomy and free will have come to an end, almost. The concept of the free will and personal autonomy is just a vehicle for explaining something that we couldn't otherwise explain. This concept is a result of lack of knowledge or understanding, and as long as our knowledge keeps developing and growing, the autonomy or the free will continues to shrink proportionally. So, from a technical point of view, an MIT, Massachusetts Institute of Technology professor, one of the leading computer scientists in the world, Alex Pentland, has put it quite precisely. It is time to recognize that human beings, like their individuality and free will as the main elements of the rational behavior, are merely a fiction. Our behavior is determined only by the social dynamics with the society, other members of the society. These social dynamics allow us to monitor people just like monkeys or bees, and through these social dynamic studies we can predict their reactions, their actions, and the way they learn new information and make new conclusions. And in some years, and this is the Pentland's quote, which goes on, in a couple of years we'll have so much information about each individual, and it will constantly be updated, allowing us to precisely calculate the actions of all human race and every person. And based on this data, we'll be able to precisely predict how society will react, thanks to the digital technologies and other methods that we will have. This is one of the leading computer scientists, by the way, recognizing the immense potential, the immense social implications of this development. So I've talked about 3 phases. I mentioned 3 phases. Now the third phase is, well, the first 2 were data collection, data aggregation and integration into big data. And the third phase, or third stage, of this monitoring is profiling, or there's the 4th stage as well, which is a key stage, feedback. You can use this data to influence or manipulate people. And in democratic countries, very subtle methods are used to manipulate public opinion. The information that we manage, the data that we manage, must be managed very carefully, and nudging is also used to access personal data apart from collecting it from other sources. And eventually this soft influence, I don't know which other computer scientist has said this, but the soft influence gives you an edge over the judicial system. In judicial system, you know exactly where the limits lie, what is acceptable and what is unacceptable. So this is how you navigate the legal system. However, through soft influence, you can manipulate people into acting in a particular way. So the question is, how we should treat this challenge, whether we should consider giving up autonomy as something good, something that we should perceive as a positive or assess neutrally. This is something that we see in the studies of computer scientists, computer sociologists. According to them, this is a new phase in the development of human race. So basically we are stepping up from the previous phase, from a world which was built around the concept of God. 300 years ago, the concept of God was substituted by the free will of a human being, putting human being at the center of the universe or the world. So we all have free will, freedom of choice, which separates or sets us apart from monkeys that are already mentioned, who are not really utilizing free will, and bees who most probably are not even aware of their free will or do not utilize the free will. That's exactly why these two sort of polar opposites are mentioned when describing this notion. So in order to understand whether it is good or bad, we must use reference values that lie beyond the challenge itself, in order for us to understand whether this is what we need or not. If we so should we continue focusing on the free will, or should we rather focus on the utopian idea that the benefit of the society and each individual can be maximized by driving the society towards a better goal, not some kind of dystopic idea of driving society towards something bad. No, it's just the contrary. If we give up our free will, and if we act as a collective, and if we strive for a collective benefit, we should reach as a collective higher benefits. And free will is very important in democracy, because we, based on our free will, continue to challenge various democratic decisions, and we could all somewhat get rid of this lengthy discussion by convincing everyone that we are driving towards a common goal. It is a political challenge, of how to do things better, which is different from a legal science, which focuses not on the benefits but on what the legal science says, on what the regulation says. So an entirely two different ways to approach the same issues: political view on a challenge, and also the civic position on the challenge, because we all as a citizen are part of the political system, or a perspective of the legal system that approaches it from the perspective of legal regulations. Is it a modern utopia that we should all strive for, or is it a threat to our society? So this is something that we should find out. And if we insist that our democracy is what it has been until now, and if the free will should prevail in democracy, then we should perceive it as a threat, and we should probably react to mitigate this threat. So we should also look at the drivers of the technological advancement, technological progress. And there's even mythical thinking when it comes to computer scientists and the value of technological progress. According to them, technological progress is like a mythical process, something that happens in nature, and you shouldn't control it, you shouldn't interfere with it, you shouldn't try to steer it towards something, you shouldn't hinder it or impede it in any ways. Technological progress should be left to its own devices and should develop naturally, whether we want it or not. And this is a mythical thinking. And I'm not even talking about artificial intelligence, which is another vast field that we could discuss very broadly. They would probably have a different perspective. But as long as human beings steer the technological progress, and as long as people can be manipulated either through rights or limiting their rights, or either letting them become a part of social processes, if it is a man-controlled progress, and there are three driving forces for that. And the first and the main driver is the business model of those companies that are driving the technological progress. They are, of course, driven by profit. So they try to advance the technologies in order to profit from such an advancement. Then there's another driver, the scientific or academic interest that urges the scientists to find out how this could technologically be possible. And the convenience of the consumers. We all want to enjoy the technologies because they make our life convenient. So there are three drivers to recap. So there's the profit, there's the scientific interest, and then there's the convenience of the customers. So desire to make life more convenient, more comfortable. And all of these three drivers or driving forces drive the technological progress, which is also picking up in speed. And that, of course, creates implications that, of course, influences the way we understand human beings, the German dimension build, or the concept of humanity as we understand it. So if we consider progress positive, that's one direction, and if we perceive it as negative, there's another direction or another route that we should take, and we should defend the existing model by all means against it. I don't want to delve into this dilemma or this dichotomy, that if we insist that the threats to free will are automatically threats to the democracy, and if we believe that technologies make us more susceptible to election rigging, which differs from the traditional meddling with the elections, it is the fact that it is done in a covert way. So in democracy, if we believe that every person has in a way untransparent living environment, so basically we have the right to privacy that nobody can impede upon, whereas government must be fully transparent. So the government or the government branches need to be transparent, whereas private life should not be transparent or open. Whereas in this other system where data is collected and manipulated, it goes the other way. So the governance becomes untransparent, whereas we as the users and our data become fully transparent or fully exposed, and it is openly available because we are surveilled on a constant basis. We are monitored on a constant basis. So this is a question which is very important for a democracy, because if we, and I wouldn't call it a utopian dream, it is in a way already has already become a reality, or partly is becoming a reality. If we opt for this scenario, then elections will no longer have any sense, will no longer make any sense. Elections will be won by those who are best at using the code ways or technologies to manipulate people, so it will not make sense to spend money on election campaigns. So that's one issue. And this, of course, needs to be further discussed, and I will probably not elaborate here. Whether it is good or bad, well, it is a threat, it is a risk, and it should be managed appropriately. So the question is the legislator or the The question is whether rights determine how the society functions, and what are the other tools that influence how society functions. There's education and there's politics that also determine this social process. So are rights or law, can law address this? So it's the legislator. Based on the existing framework, can we regulate this, or based on future, or the way that the rights should be interpreted in future or amended, should we judge based on that?
I believe that when facing this major issue, we should regulate it expressis verbis on the level of the legislator, and if possible on the constitutional level, to the extent possible on the constitutional level. Until now, many considered that it's enough that courts are engaged in it, examining some aspects of the matter. And indeed, this has increased our understanding, awareness of this problem, and we have regulated against this trend in some small areas. But the legislator's regulation would be more comprehensible. The legislator would regulate the whole field, not only separate pieces, small pieces of it. And secondly, that would be faster. Thirdly, and this, to my mind, is essential. This is the question of the further development of our democracy should be discussed in society. It's a political matter, political matter of the first level. It's not just a matter for a narrow group of lawyers or the judges. This is a matter for society to discuss. And that's why I believe that in this regard, we would need regulation of constitutional level, and such regulation exists. For example, there's Article 7 and 8 of the European Charter of Fundamental Rights, where it is expanded, but again, not focusing on the core of the problem, the way I described it, but focusing on some aspects of it, for example, private life. But this is not only a matter of private life, it's a matter of public order. And private life, of course, is a part of it and an important element, just like data protection. But why do we need private life? Why do we need data protection? That's the issue that we have to discuss, and the regulation should provide an answer to it. That's to protect human autonomy. I would formulate it like this: human autonomy, which can be regulated and put as a principle on the constitutional level. Here we also have, we see that European regulators have already stepped and have started going on this path. It's a very good beginning, but following discussions of 8 years, 2 acts have been adopted. The Act on Digital Services and on Digital Markets. Well, digital markets, that's another matter, but this Act on Digital Services, it defines minimum restrictions on surveying people. These are really minimum, and these are insignificant. But it's important that there has been the discussion about it, and that we see this discussion evolving. Actually, I criticize this draft document. Partially, this final outcome reflects this criticism, but not in full. And I believe that it is the right step, but a very weak step. I'm not going into details. So we see that regulation is possible. But then there's an objection, what can be done on the national level if these digital data are being collected globally? But indeed, it is possible. The regulation of the European Union shows it. And this regulation is quite effective. For example, regulation on data protection. And this regulation is acceptable. I will reiterate this. Regulation is not aimed at some kind of abstract force of nature technologies, like regulating this force of nature, but it's aimed at regulating human actions. This is the object of the regulation. So my proposal is that the principles that deal with this matter should be included in the Constitution. But after discussion, when we decide that such a threat to human autonomy is contrary to our democracy, but there are other opinions, and I believe that this opinion will become stronger, that this is the right thing. We no longer need this old-fashioned human autonomy. And perhaps this has been that has turned out to be objectively wrong, and that we have been determined in our actions. For 300 years, we believed that we are subjects vested with free will. But independently of this, lawyers use fictions, and even this is a fiction. If we want to remain in this fiction, this is possible. Quite intentionally, I'm not proposing any wording, any formulations today. We need a discussion, but I do believe that we need two-level regulation. First of all, basic fundamental principle in the Constitution aimed at protecting human autonomy, and that's much more extensive than privacy. Privacy looks at this private space from the point of view of an individual, and that's correct. But this space is not only the space of the individual, it's a matter for society. And until now, this issue has not been examined legally, apart from these first steps in this new EU legal act on digital services. So my proposal is to have two-level regulation in the Constitution. Fundamental principles should be included in it. Perhaps this could be done also on the EU level. But that would be a very lengthy process, however, quite possible. And then specifically, the Constitution would point to regulation in the law when more specific regulation would be included. And how can this be regulated? Well, it can be regulated indeed, dear colleagues, by taking into account those 4 steps that I mentioned. The first step is it's possible to regulate data collection. It's not like rain or wind, they just come. These data are being collected intentionally. Someone is collecting data on us. It's possible to regulate what and can be collected and the amount of data. Then the next step, joining these data into big data. This is not just happening on its own. It's not like data like magnets are drawn to each other. This is done by the respective companies or institutions. They put those data together. This is the next point that we can look at. And the third one, which I believe is very important, that's profiling. Who is allowed and when they are allowed, and what kind of rules apply when someone is making my profile. Until now, this has not been regulated. Anyone who wants to, who gets access to my data, can create my profile. And major international companies have very precise, very accurate profiles. We can really get to know ourselves if we look at our profile, but it's not accessible to us. And the next point is about use. It's in computer technologies, it's called micro-targeting. You are influenced by specific information, so to make you think and act accordingly. And again, this can be regulated by law as well. We have another issues also, design and the right to be heard. Design, which lawyers have not been thinking about. But if you have the right to be heard, then, for example, we always have to consent that we agree to Google rules spanning 100 pages. I believe no one reads those. We just agree to it. This is done formally, but the way it has been designed, we have not decided on it, and there are many other matters to discuss. Dear colleagues, I will conclude by one more idea. I have participated quite often in similar discussions, and we often hear this argument. But this is a business model of these large companies and also of the business model of smaller companies. Dear colleagues, this business model, if it causes such threat to democracy, then this is a matter of democracy, whether to accept it or to restrict it or not to accept it. And we know about many business models that are not accepted. I cannot just invent a business model and state that this is sacred. I believe that a business model is not something inviolable. We have to discuss whether this is acceptable for society. Dear colleagues, thanks. I'm grateful for this possibility to present to you these ideas. Because if we are discussing here future challenges and sustainability here, and I believe that includes sustainability of our democracy. Sustainability of our democracy is the way we see it today philosophically. It's a very important challenge of the future, taking into account the development of technologies. Of course, society in general has to discuss it, but I believe that also lawyers could engage in very interesting discussions, and especially discussions among scholars of constitutional law. Thank you.
Pateicos Latvijas valsts.
Thank you, Your Excellency, President Levitt, for this very comprehensive and even philosophically very deep address. And in addition, I would like to underline that, in accordance to the duties of the president defined by the Constitution, because the president is the guardian of constitutional values. It's important, but also Mr. Levitt's personality really shows that the protection of constitutional values is a matter very important and in the heart of our president. Thank you very much. Dear participants, we are now continuing our conference, but before we move on to our first panel discussion, I would like to draw your attention to the fact that sustainability as a value is taken into account not only when the Constitutional Court is performing its function of administering justice, but sustainability as a value is also important in the management administration of our Constitutional Court. That's why in the folders that you were handed out, these are quite, brief. We are used that usually we get folders filled with printouts and all kinds of materials that the participants of the conference can read. But you have only one QR code. You can use your smart device. you will take a photo of it, and then all the materials of the conference intended for the participants of the conference will become accessible to you. This is the steps that we have taken. If we speak about sustainability, we should be the model showing that the green thinking and sustainability policy is really the way that we have to move forwards. And now finally, I have the honor to announce the first panel discussion of our conference, and I really want to thank the speakers. And we will have the key speakers, Ms. Pauline Costello, Judge of the European Court of Human Rights, Mr. Heinrich Amadeus Wolf, Justice of the Federal Constitutional Court of Germany, my colleague Artur Skuč, Justice of the Constitutional Court of the Republic of Latvia, and Serhii Holovati, Acting Chief Judge of the Constitutional Court of Ukraine. And then Danute Jociene, who is the President of the Constitutional Court of the Republic of Lithuania, and Jiří Zemanik, Justice of the Constitutional Court of the Czech Republic, will engage in the discussion with the panel speakers. And this first panel discussion will be chaired by docent at the Department of Constitutional Law, Faculty of Law, University of Latvia, one of the professors most respected by the students, Mr. Edvins Danovskis. Please, now the microphone is at your disposal.
Your visionary speeches, which I hope will guide us through this conference, and for the kind words of introduction. Ladies and gentlemen, this aula magna of ours have witnessed visits from the Pope, the President of the United States, and other statesmen and world-renowned scientists. Today it is full of distinguished craftsmen in the field of law from very many states. Despite our various constitutional traditions and historic background, I'm sure we all wonder at this moment, wouldn't it be even more nice than these tables were covered with snacks and perhaps Prosecco to make this event even more pleasurable. However, I do hope that the first session of this conference will bring full rivers of wise words, even without any other incentives. We therefore commence our discussion titled Sustainability of Democracy: How to Prevent Threats to Democracy in a Democratic Way. Our task would be to share our various constitutional experiences regarding the self-protection of democracy, including examination of controversial issues and disputable cases. Perhaps there are even means of self-protection that rather harms democracy than protects. And by doing so, we all hope to gain new knowledge and insights on protecting this most cherished form of government. Regarding our agenda, our discussion regarding this subject will be organized as follows. As you see, we have 4 key speakers. I will introduce you even more. As you are invited to speak, you will have about 20 minutes for each speech. After these 4 speeches, there will be 2 reflections regarding issues pointed in speeches from our other distinguished panelists. And we also look forward to questions and comments from the audience when the time comes. However, my task here is to remind us all that our lives, as well as the time of this conference, is not eternal. However, I do hope that ideas presented will be. So, the first speaker today is Pauliine Koskelo. She is judge of the European Court of Human Rights. Previously, she has been a member and president of the Supreme Court of Finland and has also worked for the Finnish government in different posts. So, please.
Mr. President of the Republic of Latvia, Mr. President of the Constitutional Court of Latvia, esteemed fellow judges, Your Excellencies, ladies and gentlemen. It is really an honor and a pleasure to address you today on a subject which, unfortunately, is not merely theoretical, but highly topical in today's world. First of all, however, I would like to warmly congratulate the Republic of Latvia and its Constitutional Court on the dual anniversaries that we are invited to celebrate on this conference. While my following remarks will be personal, I do express these congratulations both on my own behalf and on behalf of the European Court of Human Rights. I have to say it was very touching to hear your wonderful national anthem at the start of this conference. And I would also like to congratulate President Levits for his very thought-provoking speech just before. Ladies and gentlemen, sustainability is one of the vitally important themes of our time. As you may have noticed, the Club of Rome, which 50 years ago sounded the alarm with the report entitled Limits to Growth, is back on the agenda. Just last week, the club published a fresh report with the title Earth for All. What is striking is that according to the experts who authored this latest report, the most important challenge of our time is not climate change, loss of biodiversity, or pandemics. The most important challenge, according to them, is our collective inability to distinguish facts from fiction. In the social media, there is an industry of falsehoods and disinformation driving a polarization of societies and contributing to a failure of cooperation and a failure to agree on even the most basic facts. With this fear, the Club of Rome are hardly alone. Indeed, the most fatal threat does not arise from the problems we face, but from the inability to respond and take proper action against those problems. This analysis has a direct link with the present topic, the sustainability of democracy. After all, rational and constructively oriented debate is a bedrock of democracy. It is simply a precondition for decision-making processes by which sustainable outcomes can be reached, both for nations and mankind in general. That bedrock is eroded if there is no longer a sufficient degree of common ground in the acceptance of basic facts or in the respect for shared fundamental values. And as we know by now, this is a poison which can be exploited and which is exploited by those who fear democracy and therefore try to destroy it. Dear participants, the ultimate essence of democracy and the rule of law is that they can ensure a system of governance which serves the interest of those who are governed and not those who govern. We may not only have hoped, but actually believed that this insight had gained solid and stable support following the collapse of totalitarian regimes on European soil decades ago. In various corners of the continent, however, we are witnessing developments whereby those who have risen to power through general elections proceed to undermine the conditions for genuine democracy and the rule of law. Constitutions adopted to establish or to restore democracy and the rule of law are meant to preserve both and to ensure their sustainability. In recent years, however, we have seen various examples of elected governments resorting to constitutional changes designed to erode the democratic order and the rule of law and to cement that regression constitutionally. Such developments in the wrong direction are dangerous and deeply worrying. Furthermore, across the ocean, one of the world's oldest democracies is currently undergoing a critical and turbulent phase where serious observers consider that the risk of a demolition of the established democratic order may be real. The specter of an old democracy being overturned in the 21st century is certainly a frightening one. Ladies and gentlemen, democracy and freedom are very closely interlinked. On the one hand, as the European Court of Human Rights has stated decades ago, fundamental human rights and freedoms are best maintained by an effective political democracy. Indeed, democracy has been described as the only political model contemplated by the Convention and the only one compatible with it. For the Court, democracy constitutes a fundamental element of the European public order. On the other hand, respect for the rights and freedoms enshrined in the Convention, such as liberty and security, and the freedoms of thought, expression, peaceful assembly, and association, are themselves preconditions for the establishment and maintenance of genuine democracy. Democracy and freedom depend on each other. This was well understood when the Convention was first adopted and is all too clearly in evidence today. When democracy and the rule of law are undermined from within, the threat therefore involves both democracy itself and the individual rights and freedoms which will only be preserved under democratic governance. The good circle where democracy and freedom sustain and reinforce each other risks turning into a vicious one where a decline in the adherence to democratic principles results in and builds upon curtailed freedom and increased repression. Examples need not be named, you know them already. Serving the interests of those who are governed and not those who govern requires a system with capacity for self-correction. No human system will be infallible or free from problems. What matters is the corrective capacity vested in that system. This corrective capacity is another hallmark of democracy and the rule of law, the importance of which is crucial. Democracy is not just majority rule. Therefore, democratic governance and the rule of law are characterized by the operational checks and balances whereby the exercise of power is made subject to constraints imposed by law and whereby countervailing mechanisms exist to ensure transparency, external review, and effective accountability. The effectiveness of such countervailing mechanisms depends on the protection of the fundamental freedoms by virtue of which those mechanisms operate, and on the independence of the judicial bodies which uphold and enforce the constraints on the exercise of power by government. Civil society, with its organizations as well as the media, as actors capable of scrutiny and opposition, are crucial forces in the maintenance of transparency and a democratic culture. An independent justice system, in turn, is vital for the maintenance for the rule of law, the protection of individual freedoms, and the possibilities of effective accountability. The importance of all these checks and balances is starkly highlighted by all the efforts undertaken by authoritarian rulers to suppress them. The most glaring illustrations are seen in places where the courts, whose role should be to protect and preserve individual freedoms, have instead become instruments of repression. Regression in the democratic governance and the rule of law is not just a theoretical danger. We have states near us where it has become an acute reality. Such backward development does not flow from a lack of standards and guiding principles. On the contrary, it occurs despite and contrary to established principles. Over several decades, the European Court of Human Rights has elaborated quite a vast body of standards under the Convention on matters of importance for the safeguarding of effective democracy and the rule of law. The work of the Venice Commission over a long time is also very valuable in this context. It is telling that the era of expansion in the membership of these institutions has just recently been reversed with the expulsion of Russia earlier this year. To recall just some of the key standards, electoral rights are, of course, at the heart of democracy. Article 3 of Protocol 1 requires the states to hold free elections at reasonable intervals by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature. Here we have the free will. This provision covers and protects both the right to vote and the right to stand for election. The crucial substantive criterion is the requirement to ensure the free expression of opinion of the people in the choice of the legislature. This requirement is relevant for a whole range of issues relating to the organization of the electoral system, including matters such as the setting of electoral thresholds, the redefinition of electoral districts and constituencies. The court has acknowledged that electoral systems seek to fulfill objectives which may not be easy to reconcile with each other. On the one hand, to reflect fairly and faithfully the opinions of the people, and on the other, to channel currents of thoughts so as to promote the emergence of a sufficiently clear and coherent political will. Thus, the reference to conditions which will ensure the free expression of the opinion of the people essentially implies the principle of equality of treatment of all citizens in the exercise of their right to vote and stand for election. It does not follow, however, that all votes must necessarily have equal weight as regards the outcome of an election, or that candidates must have equal chances of victory. Any alleged attempt to distort or manipulate the electoral system in favor of a given party or political movement, however, would fall to be assessed against the obligation to ensure the free expression of the people's will. The right to elections also imposes on states certain obligations of a procedural character, in particular by requiring the existence of a domestic system for the effective examination of individual complaints and appeals in matters concerning electoral rights. The existence of such a system is one of the essential guarantees of free and fair elections and an important safeguard against arbitrariness in the electoral process. Accordingly, the decisions must be taken by a body which can provide sufficient guarantees of impartiality. The scope of discretion must be defined with sufficient precision, and the procedure must guarantee a fair, objective, and sufficiently reasoned decision. Now, as the free will of the people is a key notion for the electoral rights, it is obvious that what is crucial for the outcomes of the democratic process and ultimately for the sustainability of democracy itself are the conditions under which the will of the people is formed. Is the will free or manipulated? Is it rational or is it delusional? And here I move on to that aspect a little bit. Democracy dies in darkness. This phrase, coined as the slogan of a famous newspaper, is undoubtedly true. And it is well known that the European Court of Human Rights has forcefully and consistently underlined the essential role of the freedoms of expression, peaceful assembly, and association in a democratic society. It has always placed special emphasis on the particular role of the press and other public watchdogs, such as NGOs. At the same time, the especially high level of protection afforded to such watchdogs also entails particular responsibilities. The special protection is subject to the condition that they comply with duties that must be required from those with the ambition of fulfilling the function of public watchdogs. The particular safeguards in relation to reporting on issues of general interest demand that the reporting is done in good faith, on an accurate basis, and provides reliable and precise information in accordance with the ethics of journalism. Thus, for instance, the notion of responsible journalism does involve duties of reasonable verification. Furthermore, the high level of protection attaches to reporting and commenting on matters of public concern, but does not condone gratuitous personal attacks damaging the reputation of others, such as critics. This also is a growing problem these days. Nor does freedom of expression allow hate speech. Content which runs counter to the basic values underpinning the Convention does not enjoy its protection. In short, the standards of public debate set out under the Convention are designed to promote and to safeguard the kind of scrutiny, criticism, and argument which are essential for genuine democracy. By contrast, fake news or other kinds of disinformation, hate speech, or baseless personal attacks on those who voice criticism are in principle not protected. Thus, the problem we face today does not really lie in the lack of standards. What is clear, however, is that the setting and the interpretation of the boundaries in all possible concrete circumstances may involve, and does very often involve, difficult and delicate assessments, and that modern conditions also may require updating of the standards in various respects. An even greater problem arises from the particular difficulties of enforcement of the standards in the modern communication environment. The institutions of the state in charge of the enforcement of laws and the standards are in practice not well placed to be able to cope with the speed and volume of content that is spread, tailored, and targeted by electronic means. Combating the dangers posed by the rapid flooding of falsified, distorted, or hateful content by way of law enforcement may often be too slow or ineffective. The only real option may be to try to expose and correct the falsehoods, to compete the flow of information with better information. Yet another problem, however, arises where people are no longer receptive to objectively correct information. This, again, seems to be a growing problem too these days. Esteemed audience, freedoms are subject to limits imposed by the rights of others and by the exigencies of the collective imperatives of protecting and preserving democracy. The role of courts will always remain vital for the setting and for the updating of standards to guide the necessary and difficult balancing exercises. What is also clear, however, is that the value of our laws, our constitutions, our freedoms, of the rule of law and of democracy itself must remain alive in the hearts and minds of the people. It is therefore of vital importance to do all we can to ensure that the close and tight links between democracy on one hand, our freedoms, and on the constraints on power inherent in the rule of law on the other hand, are understood and appreciated by all. The opposites may be good teachers in this respect. Authoritarian regimes spring from a contempt for genuine democracy, its transparency, and its constraints on power, and they end up in fear of the same. The sustainability of democracy and the rule of law depend not just on strong institutional support, but on the diligent and constant cultivation of a living sense of their value throughout society. We can take nothing for granted. Harking back to what I began with, we may recall one of the many wise thoughts of Hannah Arendt. She wrote, a long time ago, that the ideal subjects of totalitarian rule are people for whom the distinction between fact and fiction, true and false, no longer exists. These perils cannot be ignored. Understanding them in time may hopefully help us maintain democracy and the rule of law. I thank you for your attention.
Thank you, Judge Koskelo, for your first speech. And the next speech today will be given by Heinrich Amadeus Wolf, Justice of the Federal Constitutional Court of Germany. Judge Wolf has studied law in Regensburg, Tübingen, Bonn, Freiburg, and Heidelberg, and he has obtained a doctorate and a habilitation at the German University of Administrative Sciences. He is also a professor of public law in Munich, has been professor of public law in Munich, Frankfurt Oder, and since 2014 he is professor at Bayreuth. So please, Justice.
Thank you very much. Mr. President, President of the Constitutional Court of Latvia, President of the Constitutional Court of Europe and the world, Excellencies, dear colleagues, ladies and gentlemen. It's an honor for me to be here today on behalf of the General Federal Constitutional Court at the conference marking the 25th anniversary of the Constitutional Court of Latvia. The President and the Vice President of our court were regretful unable to attend, but they both sent their regards and best anniversary wishes to the Constitutional Court of Latvia. Before I begin, please allow me to make two personal remarks. First, I would like to ask you to excuse my English skills. In 2013, I took a research sabbatical in Ireland. Whenever I started speaking English, the facial expression the person I was talking to changed from relaxed to highly concentrated. You could literally see the question in their eyes, what on earth is he trying to say? An Irish friend of me, Yvonne Scannell, a professor of environmental law, said that my English is so funny I could make a lot of money on television. Despite her advice, I stayed in law. Secondly, I'm the newest member of the German Federal Constitutional Court, as I was appointed quite recently, 3 months ago to be exactly. Therefore, I'm still learning to adjust to my new role, especially when it comes to speaking strictly on behalf of the court and having to completely set aside my personal views. The topic of our discussion is sustainability of democracy, how to prevent threats of democracy in a democratic way, and what is the role of the Constitutional Court in this context. When discussing this topic, we must first take a look on the respective constitution. Section 1, the Constitution Order. First of all, it is important to clarify the terminology. In this context, sustainability is not meant in the technical sense, how it's typically understood as an economic, social, and environmental concept. Rather, in the context of our discussion, sustainability refers to durability and balance. Ensuring a sustainable political order is a crucial objective of the German Constitution, our basic law, which first and foremost constitutes a response to the Nazi regime that ruled Germany from 1933 to 1945. One of the factors that made the rise of National Socialism possible was that the previous German constitution, the Weimar Constitution from 1919, did not attach sufficient importance to safeguarding a sustainable political order. In German basic law, the aim to ensure sustainability is primarily reflected in the following 6 aspects. First, the German basic law does not recognize traditional emergency power. Even in times of crisis, the basic law does not generally allow for the suspension of the regular rules and order. Instead, the general system of limitation is flexible enough to accommodate the specific circumstances of the individual case. Second, the basic order provides for strong representative elements at the federal level. In this respect, only one state organ, the German Parliament, Bundestag, is directly elected by the people. No other state organ can claim to be on par with the directly elected parliament in terms of democratic legitimation. Third, the constitutional mandate of parliament is designed in a constructive manner. Parliament does not have the power to dissolve itself, and it can only vote out a sitting federal chancellor if it elects a new chancellor in the same time. Fourth, Germany, as a sovereign state, is part of a peaceful international order. Fifth, the democratic right of persons who fight against our democracy can be restricted. We call this concept militant democracy. I will explain this point in a second. Sixth, the basic law has established a strong constitutional court. Section 2, the role of the Federal Constitutional Court. I would now like to discuss the role of the German Federal Constitutional Court in protecting a sustainable democratic order, in particular the following four aspects. First, given effect to the procedural rights. The Federal Constitutional Court gives effect to the strong procedural rights that are guaranteed by the basic law. First and foremost, this concerns constitutional complaints. The 16 judges of the General Federal Constitutional Court deal with more than 5,000 constitutional complaint procedures every year. The hurdles for filing a constitutional complaint are not very high. No court fees apply, and complainants do not require legal representation. In exceptional cases, complaints may directly challenge an act of parliament rather than only individual implementation measures. The Federal Constitutional Court takes its roles as a citizen court very seriously in its daily work. For example, this is illustrated by the fact that the court only imposes abuse fees in extremely rare cases. Similarly, the court treats each matter with respect, regardless of how incomprehensible the matter at hand may be. It's really true, I know it. We regret to other types of procedure, too, the court renders its decision independent of the political opinion at issue. This concerns, for instance, procedures for the prohibition of political party, so prohibition of association, and disputes between constitutional organs, which we call enshrined. It is especially important in cases in which the opposition challenges the actions of parliament or government. Second, democratic rights. Democratic rights are especially significant for ensuring a sustainable democracy. These include electoral rights, freedom of expression, freedom of assembly, freedom of political parties, and freedom of association, as well as the right of resistance, although this last right is not very relevant in practice. These rights are not absolute, although the content and scope of their limitation may differ. A. Limitations that are relatively unproblematic are those that are necessary for the protection of the other constitutional interests, including other fundamental rights. For example, freedom of assembly can be restricted in order to protect health in the context of the spread of COVID-19, but only as a last resort and following an appropriate balance of interest. Freedom of expression is limited by the protection afforded human dignity. With regard to the principle of free election, the consideration of protected interest inherent in the Constitution leads to a strengthening of voting rights. In accordance with the unwritten principle of public election, voting computers may only be used in the way in which votes are counted remains transparent. At the same time, to protect the proper functioning of Parliament, the principle of equal elections is restricted in material respect. A party can only enter the German Bundestag, our parliament, if it clears a threshold at least of 5% to the votes cast for the party list. This restriction has long resulted in stable parliamentary majority. However, the Federal Constitutional Court has reservations regarding the application of this electoral threshold and the underlying constitutional principle to municipal and European elections. B. Further limitations arise from the possibility of restricting fundamental rights through acts of parliament. The basic law allows for such restriction, including with regards to democratic rights. However, in its interpretation, the Federal Constitutional Court takes a narrow approach regarding permissible restriction. According to the court, such restrictions may only be imposed if the law in question seeks to protect a legal interest that, while not necessarily a constitutional interest, must be equivalent in importance to the fundamental right in question. For instance, fundamental right may be restricted to protect life and limb. Assemblies may thus be prohibited, for example, in a high security zone established for G7 summit, especially when it comes to restriction of freedom of expression. The content of the view in question are largely irrelevant. According to the limitation clause in Article 5, subsection 2 of the Basic Law, freedom of expression may only be restricted by a general law. This category only covers legal provisions that are not directed against specific views as such, but serve to protect a legal interest per se. To meet that requirement of a general law, the legal interest in question must be generally protected by the legal order, regardless of whether violation occurs through the expression of opinion or another way. But in this respect, too, there are exceptions to the requirement of a general law, specifically exceptions serving to prevent propaganda affirming to the Nazi reign of violence and tyranny. The Basic Law does not provide for any specific safeguards against fake news. Regarding state actors, informing rights require that the information provided must be accurate or must at least have been reviewed to the greatest extent possible. The situation is different for information provided by no state actors. Fundamental rights have only limited effects in relations between citizens. While the Basic Law does not exactly contain a prohibition to spread false information, constitutional protection is highly reduced in case of fake news. The intentional spreading of false information is not protected by freedom of expression. A personal opinion that is based on incorrect facts merits less protection than other personal opinion. However, in this determination of whether a statement is an expression of opinion or expression of fact, freedom of expression must be taken into account. The third limitation arises from the limits set by the principle of militant democracy for several democratic rights. Freedom of political parties, freedom of expression, freedom of association, or other fundamental rights can be restricted if these freedoms are used against the free democratic order, the basic order. The Federal Constitutional Court has given specific shape to the term free democratic basic order and developed a detailed standard that is applied in this regard, with some variation depending on the context. The scope of what constitutes the free democratic basic order is limited to certain principles, namely to the principle that guarantee the rule of law on the basis of self-determination of the people in accordance with the will of the current majority, and that guarantee freedom and equality, with excluding any reign of violence and tyranny. On this basis, the Federal Constitutional Court has specified 8 elements of the free democratic basic order, which are not exhaustive. These 8 elements are respect for the human rights set out in the Basic Law, above all for the right to the free development of one's personality and the right to live, the sovereignty of the people, the separation of the power, the accountability of government, the lawful conduct of the administration, the independence of the judiciary, the multi-party principle, and equal opportunities for all political parties, including the right to form an opposition. These limitations are of practical relevance when it comes to freedom of association. In this regard, the court found several bans of association imposed by the responsible ministry to be compatible with the Constitution. This situation is different when it comes to the prohibition of political parties. In the last 60 years, the Federal Constitutional Court did not ban a single political party, but there were 2 unsuccessful proceedings initiated against the Nationaldemokratische Partei Deutschland, NPD. The possibility of depriving extremists for fundamental right protection in certain constellation is even less relevant. There has never been a case in which the Federal Constitutional Court decided that someone has forfeited their fundamental right. Application to this effect were always dismissed as inadmissible. The Federal Constitutional Court exercised restraint when it comes to these powerful instruments of a militant democracy, but they form part of the Constitution and have their role to play in the constitutional order. Third, equal opportunities of political parties. The Federal Constitutional Court is cautious when it comes to the competition between political parties. It distinguishes between dispute within and outside of Parliament. Outside of Parliament, the Federal Constitutional Court has developed the following principle. Political opinion forming must be a bottom-up process. This means that opinion developed from the people to the state organ rather than the other way around. Members of state organs are allowed to provide factual information to the people, but may not take sides when political parties compete. According to a recent decision of the Federal Constitutional Court, this principle has been violated by the former federal chancellor in her role as a head of government when she publicly disapproved of the election of a minister-president in one of the German Länder, federal state, who had been elected with the support of a right-wing party, the Alternative für Deutschland, AfD. The court is less strict in cases where Parliament withholds parliamentary posts from certain parliamentary groups. Given its size in Parliament, the parliamentary group Alternative für Deutschland would in principle be entitled to design a parliamentary vice president and several chairs of parliamentary committees. However, the parliamentary majority did not elect the candidate for the post of vice president proposed by AfD parliamentary group. The Federal Constitutional Court found no breach of constitutional law. Another dispute of this nature is still pending. The court has yet to decide whether the recall of a committee chair by the majority on the committee was constitutional. Fourth, protection of the foundation of democracy. Protection democracy also means having regard to the unity of the people as the basis for democracy. Over the last few years, the Federal Constitutional Court has highlighted 2 aspects for this objective. First, it derived a right to an existential minimum for the guarantee of human dignity. In principle, every person in Germany is entitled to the means they require to survive and to take part in a minimum of social and cultural activities. The court also found that the fundamental right in their dimension as defensive right against state interference give rise to intertemporal guarantees with regard to climate protection. Precautionary steps may be needed today in order to prevent potential damage to the natural foundation of life that cannot be reversed once it has occurred. This concept has not been applied in the same way to social security system. Let me conclude. There is no miracle cure to protect sustainability and democracy. Democratic rights can be used against democracy. In such use, it is to be prevented by restricting these rights. Such restrictions still amount to interference with democratic rights and thus require justification. While certain exceptions may apply in special constellation, the general constitutional framework for justification to interference must not be set aside. No, not all situations can be resolved in the same way. Thank you for your attention.
Thank you, Justice Wolf. I think that colleague of yours was quite wrong. Your English was excellent. Translation was hardly necessary. I know that you have been appointed Justice of the Federal Court just recently, so very best luck of you in this position, and who knows, maybe someday in television. So the next speaker is my beloved colleague Artūrs Kučs from Latvia. He is judge of the Constitutional Court of the Republic of Latvia since 2006. He also is associate professor at the Department of International and European Law of the Faculty of Law of the University of Latvia. He is teaching several courses on international and European law, and he has also been appointed as ad hoc judge to the European Court of Human Rights, and his research interests are devoted to freedom of speech doctrine in various aspects. Please, Artūrs. And Artūrs will give his presentation in Latvian, so you can enjoy our beautiful language.
Paldies.
Thank you for the kind introductory words, Honourable President, colleagues, ladies and gentlemen. At the time when war is waged by Russia against Ukraine, Latvia, like other neighboring countries and Europe as a whole, is very much focused on defending their independence and democracy, and what needs to be done, as Madam Skella mentioned, ways of countering disinformation, which is very relevant because one of the current challenges is that if I can't convince you of my position, of my truth, then I can at least undermine your trust in any kind of information. So anyone who's trying to distort the information, anyone who's trying to restrict by means of force the freedom of association are undermining the fundamental constitutional values. Therefore, in Latvia and beyond, among scholars and practitioners, we hear talks about whether we are able to protect fundamental rights, how should we assess or how should we treat any restrictions of the fundamental rights during the war? Are there any other ways to upgrade those safeguards, or those safeguards in place? And I think that everyone will agree here that we can impose restrictions on fundamental rights to protect our democracy. And we have seen a number of times in past that we shouldn't take democracy for granted. As my colleague, the president of the Constitutional Court, underlined, the state and the society is responsible for the protection of the democracy. The concept of militant democracy is not new. It appeared in 1937 due to the wish to fight against fascism and Nazism that was ruling Europe at the time. And the main traits of the democracy are typically pluralism of political ideas and views, and at the same time it also implies that democracy can destroy itself, namely democracy itself facilitates process where persons, by exercising these democratic freedoms contrary to their aims, may harm or even overthrow democracy. Democracies, however, do not become anti-democratic overnight. Therefore, the opinion has taken for that intervention is necessary before it is too late. So it is a gradual process, and it's been mentioned that we could intervene in advance proactively to avoid such regression as has been mentioned, and also as has been mentioned before me during the COVID and with respect to the Russian invasion of Ukraine, we see that there are facts that people do not support, and there's no place for dialogue. I mean, people do not accept facts that are evidence-based and should not even be defended, and that's it. Militant democracy defends democracy against persons who want to overthrow, destroy it by abusing democratic measures. It manifests itself as a preventive restriction of civic and personal rights. According to the Latvian Constitutional Court, a democratic state governed by the rule of law uses the principle of militant democracy to protect its constitutional bodies and institutions of national security against persons who, through their actions, jeopardize the independence of the Latvian state and the principles of democratic state governed by the rule of law. A typical militant democracy fights against hate speech, restricts disinformation, it bans anti-democratic political parties to defend itself, may restrict protests or marches, and I will also talk about the election criteria or requirements towards various candidates. So, in other words, democracy, if it needs to be defended, may lead to certain restrictions on personal civic rights. Although the concept of democracy is not new, its meaning and concept are evolving and changing, and discussion whether the restrictions derived from it can be democratic and lawful continues as we speak. The question has been posed in the legal doctrine whether democracy may fight against threat to its existence in an anti-democratic way, or should the militant democracy comply with core of democracy and thus ensure that political decisions are adopted as a result of free political struggle or competition, rivalry, and also the question where should we draw the line between the protection of individuals' rights and the principle of militant democracy. And in my speech, I would like to briefly describe how Latvia has tackled this task, also through the case law of the Constitutional Court, and how tackled it during a debate about the National Electronic Mass Media Council decision to prohibit Russian media in Latvia. I have to apologize to my colleagues from the Supreme and Administrative Courts, respectively, who are also dealing with these issues of the militant or self-defending or defensive democracy. Due to lack of time, I omitted mentioning them, but in my article that will be published in the compendium, I've included also the case law of the administrative and, of course, the Supreme Court. As regards to the case law of the Constitutional Court, the militant democracy principle has been thoroughly analyzed in the case law. It is even a part of the preamble, mentioned in the preamble of our Constitution. In recent years, Constitutional Court has examined it in at least two of its decisions. The first that I would like to mention is a case which is linked to personal rights, or the restriction of personal rights to get elected to the parliament, be listed for the parliamentary elections. As colleagues already mentioned, voting rights and the right to be elected is one of the key rights in a democracy. In this case, an individual, and I should mention it at the start that we do not allow individuals who were members of the Communist Party, active members of Communist Party, after the 13th of January 1991 to be listed for the elections. And for the colleagues from abroad, I'd like to also clarify that We're talking about the extreme wing of the Communist Party that supported the August Putsch in Moscow in 1991. So basically, they also tried to overthrow the Latvian government, the newly elected independent Latvian government, and they also wanted to punish criminally those who voted for the independence. And one of the individuals from this, extreme communist wing submitted a constitutional complaint to the Constitutional Court challenging the election restrictions and their constitutionality. And I should also mention that Constitutional Court in 2000 and 2006 had already reviewed the challenged provision of the Constitution, had found this provision constitutional, but also indicated that legislature must regularly review whether such restrictions are still applicable or viable. And the European Court of Human Rights, also its extended panel, reviewed the complaint submitted by Madam Ždanoka and noted that restriction in the case of Latvia as a young democracy is acceptable, is justifiable. At the same time, court underscored that Parliament should regularly review the need to continue such restrictions or extend such restrictions. And Constitutional Court back in 2018, which was 4 years ago actually, as it reviewed the justification or the proportionality of such a restriction, recognized that it is objective was to prevent the person which is questioning and undermining Latvia as a democracy and an independent state be allowed to take part in the elections. And according to the court, such restrictions were found to be still legitimate. And although researchers recognize that Latvia is a democratic country, unfortunately, in society, among people, democracy is not fully or widely accepted value. As regards to the proportionality of the restrictions, court indicated that a state may protect its democratic system by regularly evaluating the threat level or risk level, and then decide whether to maintain the restrictions or reduce them. And as in the previous of its judgments, it also indicated that these restrictions should be temporary, should be reviewed regularly in order to understand at which point to discontinue such restrictions. Court also underlined that the challenged provision is not against pluralism or any political views, does not restrict any political views or pluralism, and is, however, instead aimed at restricting individuals that are undermining independence and democracy of Latvia and Latvian system governed by the rule of law. Challenge provision, however, does not prevent people from their political activity and joining a political organization. Last but not least, also considered the provisions of the parliamentary election law, which provides mechanisms for individual assessment of each candidate in order to ascertain whether the restrictions provided in the law should be applied to the person in question. Or in other words, the Central Electoral Committee, which registers the candidate list, must also not only ascertain that a person is a member of a political party, but should also evaluate whether the candidate or a person is still a threat to the independence of Latvia and the democratic system of Latvia governed by the rule of law. And this decision can also be appealed in the administrative court by a person in question who's been restricted or prevented from participation in the elections. All that said, the court concluded that this provision is fully constitutional. We nevertheless had quite a heated debate with our colleagues, and I had even a colleague who thought otherwise, and he indicated that by singling out such small group for the sake of militant democracy does not provide for the equality of treatment. At the same time, I'd like to also underline that the constitutional review of this provision also showed how closely militant democracy is linked to the social, policy, and geopolitical status of the state. You know, the sort of integrity or the strength of our civic society, our political tradition, and our geopolitical location to a large extent determines how courts approach such issues. So the principle of militant democracy may therefore be applied differently by different countries in different political, historical contexts and geopolitical contexts. Another judgment that I would like to specifically underline is focusing on the freedom of expression, and also draws the limits, or shows where the limits of the militant democracy are. In this case, a complaint was submitted to the Constitutional Court challenging criminal court provision regarding public attempts to undermine the independence of Latvia and calls to annex Latvia to other countries. A complaint was submitted by a person who has published online a note urging Latvia to be incorporated into the United States of America. According to the provision of the criminal law, they were held liable. A proceeding was initiated against them, and they complained that this is a restriction of freedom of speech. And according to the defendant, he published the announcement or this note or call to draw people's attention to the fact that another person has been penalized for similar activities, online activities, encouraging Latvia to be, or urging Latvia to be incorporated into the Russian Federation according to the constitutional law. International fundamental rights do not prevent persons from calling to amend the fundamental values and basic principles of a democratic society. Although those ideas might be shocking, they still have the right to encourage changes. From the freedom of speech point of view, according to the court, any call or incitement to armed conflict or any attempts to undermine the public order and democracy are beyond the scope of this provision. So according to the court, the criminal law provision does not imply penalties for the incitement to any changes in the government principles and government bases, and the court ruled that only those views and opinions that create true risks for the democratic society and the government are to be punished. So, in other words, it applies only to real threats and thus contributes to the implementation of the militant democracy in practice.
Whether the particular person, his actions and his statements caused a genuine threat to this is examined by courts of general jurisdiction. This is not within the Constitutional Court's jurisdiction. And this ruling by the Constitutional Court outlines limits to applying this principle, stating that not only the fact on the statement should be examined, but also whether it causes genuine threat to independence of the Republic of Latvia and to its democratic state order. As I mentioned before, another issue which I would like to touch upon, and this has been discussed widely and extensively not only in Latvia but also in the European state, these are the decisions by the National Electronic Mass Media Council on blocking Russian media in Latvia. So this National Electronic Mass Media Council, or the Council, on the 24th of February decided to prohibit distribution on the territory of Latvia 3 Russia-related TV programs that posed a threat to national security. And the Council noted that this was the first decision of this kind adopted in the history of the European Union on the basis of a norm included in Audiovisual Media Services Directive, which allows in urgent cases to derogate from the time-consuming procedure for restricting programs. The Council established that these channels were disseminating appeals that pose threats to the national security. For example, in the programs broadcast on these channels, an opinion was expressed that the Baltic states should be recognized as being the territory of Russia, and also a pronouncedly negative narrative against Ukraine and NATO member states had been used. A couple of months ago, the Council adopted a broader decision prohibiting distribution of 80 Russian TV programs until the moment when Russia ends its aggression in Ukraine, thus discontinuing to undermine the territorial integrity, sovereignty, and independent statehood of Ukraine. And this prohibition and the decision was adopted on the basis of amendments to the electronic mass media law introduced by our parliament, which provide for the prohibition to distribute an audiovisual program of electronic mass media of another state if the country of its jurisdiction undermines or threatens the territorial integrity, sovereignty, or independent statehood of another state. And the purpose of these amendments have been indicated as protection of Latvia's informative space, its information space, and also that Latvia should not finance and is not providing revenue to such programs and services which create materials of this kind or content of this kind. In connection with the Council's decision, several legal proceedings have been initiated in administrative courts, but I'm not going to comment on it because these rulings are still pending. But there has been discussion in Latvian society regarding the extent to which the state should restrict a person's right to access information. As we know that also the Court of Justice of the European Union quite recently adopted a decision in connection with France, Russia Today, and it also recognized this restriction as being proportionate. But also among legal scholars and academia, also this judgment by the Court of Justice of the European Union has been criticized. But for us, for judges, if this criticism is constructive, and we just have to get used to it. It characterizes us as a democratic state, meaning that our judgments and rulings are being read and being criticized. For example, one of the most known scholars of the freedom of speech, Dirk Voorhoed, has noted that the European Union had radically restricted society's right to receive information, and that citizens of the European Union, media, journalists, politicians can no longer access the content of these TV programs and can no longer understand how Russia is trying to mislead or manipulate public opinion. I would say that these opinions outline the problem of blocking Russian media from the perspective of human rights. But at the same time, I would also say that both COVID pandemic and also Russia's aggression in Ukraine, the way it is reflected, but also election of the President of United States, it all reveals what kind of impact this information might have upon voters, democracy, civil society. How it can undermine trust in state institutions, create tension in society, and of course have negative impact upon the decision-making process of democratic institutions. So in cases like these, balance should be found between the interests of protecting democracy and civic freedoms, for example, the right to the freedom of speech and the right of society to receive comprehensive information. This task is not easy, and this is one of the tasks for our judges to perform. Thank you.
Thank you, Arturs, for sharing the Latvian experience in safeguarding democracy. And the last key speaker in today's discussion is Sergei Holovati, who is Justice of Constitutional Court of Ukraine and acting Chief Judge of the Constitutional Court. He has also held various positions in the Council of Europe. Please.
Thank you very much. Your Excellency, Mr. President of the Republic, Honorable President of the Constitutional Court of Latvia, distinguished participants of this conference, ladies and gentlemen. First of all, I would like to express from my heart deep gratitude to the Constitutional Court of Latvia for inviting our delegation for this event, and as a result for a possibility to have a moment of, I would say, happiness, because we forget how to joke, to smile, or even laugh. We cannot do it at home, but we did it yesterday, and we have returned into atmosphere of everyday life before the events whom all of you know very well. Thank you very much for that. Dear ladies and gentlemen, this year, 2022, Latvia celebrates the centennial of its constitution as the fundamental law of the independent republic and democratic state. My country, Ukraine, could also have celebrated a similar centenary of the constitution of Ukraine's People's Republic, adopted in April 1918 by at that time, the Parliament of Ukraine, Central Rada. However, Russian Bolshevik military aggression against independent Ukraine drowned Ukrainian national revolution of 1917-1921 and Ukraine itself in blood. As a result, after almost 3 centuries as a colony under Russian Tsarism, Ukraine was colonized by Russian communist totalitarianism. After the fall of the Russian Empire, Ukrainians could not defend their statehood as they were not supported geopolitically. At the beginning of 1918, to defend itself from the Bolsheviks, the Ukrainian movement entered an alliance with Germany. However, Germany lost the First World War, and the Ukrainians found themselves in the camp of the defeated. In one sense, if Germans had won in 1918, then the Ukrainian state may have stood, and we could now celebrate not its 30th anniversary, but its centennial. Unique among European nations, Ukraine has a tradition of more than 1,000 years of state building, but yet only in 1991, finally, it was possible for Ukraine to become independent. And we assumed that it had become forever. It would appear almost unimaginable to think that the very existence of independent, democratic, Western-oriented values Ukraine would be completely unacceptable for the ruler in the Kremlin. In fact, it is regarded as fully incompatible with the aims and purposes of Moscow's fascist-type empire. Today, Moscow's neo-Bolsheviks practice the most disgusting practices of the Nazi and communist totalitarian regime, treating the Ukrainians, desperately defending their freedom and their identity, as subhumans. Under these circumstances, the ideals of human rights, of the rule of law, and of democracy are very far from the realities of life today in my country. Indeed, the question of the very existence of the Ukrainian people and Ukrainian statehood is at stake. The Muscovite strategy is about depriving Ukrainians of their right to life, to exist as a nation, and about killing Ukrainians just because they are Ukrainians. In short, we are witnessing a genocide against the Ukrainian nation. Nevertheless, the forum dedicated directly to 2 anniversaries of Lithuanian constitutionalism, definitely we have to deliberate about democracy, human rights, and the rule of law. Let me start very briefly to shed a light on Ukrainian, I would say, some specific feature of Ukrainian people. For that purpose, I have back to the history, and yesterday in the National Library of Latvia, I more extensively explained who are we Ukrainians. And dating back to the beginning of the 18th century, we have a memorial document which is called in Ukraine as the Constitution, but is not the Constitution. It was an agreement between the freely elected hetman, that is the leader of Cossack nation, and the Cossacks themselves. And this document says the Cossack people were always speaking against autocracy. The rule of man was not inherent in the motherland, that is in Ukraine, and in the Zaporozhian host, that is the Cossacks military man. So, in general, that document dates back us to what? To the origins of the Ukrainian constitutionalism, because it was this document teaches us that Ukrainian Cossack nation was based on 3 values or 3 ideologies. Ideology of freedom, they want to be free from the Moscow yoke, they want freedom for Cossacks, that's liberty and republicanism because the leader was elected freely, and Christianity, because Christianity was adopted in Kyiv more than 1,000 years ago. And so that's why these are the origins of our, I would say, constitutionalism, our national identity as Ukrainians who were for centuries striving, fighting for freedom. And Ukraine appeared to be the last among all post-Soviet republics to adopt a new fundamental law. We have adopted it in 1996. At that time, the Venice Commission analyzed our constitution and said that it was the adoption of, the adoption of the new Ukrainian constitution on 28 June 1996 was a major event in the sphere of the European constitutional law. However, the Venice Commission also made a remarkable, I would say, statement or very important remark that in the view of the Venice Commission, the 96 Constitution resulted in the concentration of powers in the hands of the President. And the text of this 96 Constitution did not take into account realities in Ukraine, provide for sufficient checks and balances. And there was a risk of authoritarian presidential system. That was the conclusion. And if you look at the more than 25 years period of this 96 Constitution, we may say that during all the years since the Constitution was passed, virtually each of the 5 presidents attempted to change the Constitution to his own advantage or to act not in complete compliance with it for the same purpose. In my written paper, it is in detail explained all the process from 96 until now, but I will give you only 3 or 5 examples. The first attempt to attack the Constitution was President Kuchma. You know very well this name, autocratic ruler. And what he attempted to do, he attempted to put on referendum, because all autocrats, they like referendums, use referendums for establishing their rule. So President Kuchma has announced national referendum for the constitution to be adopted of the same model as the constitution exists in Russia, Kazakhstan, and Belarus. That means two-chamber parliament with the one chamber appointed by the president, and that was Kuchma's aim in 2000, that is 4 years after the constitution was adopted. Even it was a risk, the 96 constitution was a risk for authoritarian ruler, but he wanted more power, and the Constitutional Court of Ukraine rejected this attempt because Kuchma announced a referendum at which the people were asked, would you like to replace the 96 constitution with a totally new one, directly in the referendum? At the time, Ukrainian Constitutional Court said this question is unconstitutional because the Constitution of Ukraine does not allow to put the new constitution directly to people. Firstly, you should go through the parliament, and then possibly you will do that. By rejecting in 2000 Kuchma's scheme, the court ensured future Ukraine could evade developments like those that had occurred in Belarus or Kazakhstan, where referenda were used as instruments to excessively strengthen the president's power. The second example, again, under the Kuchma's rule, 2003, Kuchma's controlled parliament adopted the law saying that the parliament could define its powers not only by ordinary law. So additionally to the powers defined in the Constitution, the Rada could extend their powers. Certainly, the Constitutional Court at that time, under the Kuchma's rule, said no. The powers of the president could be defined exclusively in the Constitution. I have mentioned only two concrete and democratic examples of positive solutions to prevent threats to democracy at the initial stage of constitutional consolidation in Ukraine, which were institutionally made by the Constitutional Court. Third example, negative. If there were two positive, we have approach to the 2010, the years of the creeping personalistic rule of pro-Moscow Yanukovych, the president who is now living in Russia, that was real rule of man, where all the power were concentrated in his hands. He controlled totally the parliament and the judiciary, and even he captured the Constitutional Court. And the Constitutional Court made the ruling to give him more powers of the same type that were in 96 Constitution, but before there was Orange Revolution, which transformed Ukraine from the Constitution 96 to the presidential parliamentary into the parliamentary presidential, because Yushchenko was the winner, and Yushchenko was the pro-Western and so to say pro-Ukrainians. He was nationalist and pro-Western president, so he was stripped off of those powers which Kuchma had, but Yanukovych was granted by the Constitutional Court in 2010. So it was unusual, and Venice Commission said also that it was unusual that Constitutional Court could change the political system, but in Ukraine it has happened, and that was the key player, and the key role was played by the Constitutional Court, unfortunately. And the some last examples. For example, during the Kuchma's rule as well, the Rada has adopted the law, another attempt to put the new constitution on referendum. Parliament under the Yanukovych rule has passed the law allowing to put on the referendum the new constitution. Again, probably with the same model as it was drafted in the Kremlin. But the Constitutional Court defined that law unconstitutional, stating some very important positions, legal positions, that people, while possessing the sovereign prerogative regarding the exercise of constituent power, at the same time is within the limits defined by the Constitution regarding the order of its exercise. That meant that Constitution, being the results of the exercise of the constituent power by the people, by establishing the order of amendments to it, determines the procedural limits for the exercise power by the people themselves, so that people are abide by the rule of law. And so in this way, the Constitutional Court did not allow the Parliament or the new attempt to change the Constitution to be performed. And the last example, I have 5 minutes, the last example after the last presidential elections, in 2019, newly elected president initiated 7 amendments to the Constitution, and they come to the Constitutional Court. The result is, in total, out of 7 initiatives of the president to amend the Constitution put forward by him immediately after his election, the Constitutional Court rejected 4 of them, considering their implementation as the threats to democracy and as the threat to the separation of powers. So I would say that the 96 Constitution was, as Venice Commission assessed, contained the risk of the creeping authoritarianism, but in 2016 there was fundamental constitutional reform in Ukraine, and it was done thankfully to the valuable contribution of the Venice Commission. Indeed, it is difficult to imagine Ukraine as the dynamic democracy that is today without the Commission's steely assessment of its progress, keeping the country on the straight and narrow democratic path. There is no doubt in my mind that it was the guidance of the Venice Commission that helped shape Ukraine's modern constitutional development according to the patterns of Western democracies. The influence of the Venice Commission in guiding, educating, and cajoling Ukraine into the institutionalization of democracy, the rule of law, and human rights has had a profound impact on Ukraine's unalterable integration into the European family of democratic nations and traditions. In effect, the Commission became the backbone of the Ukrainian legal system. The path taken by Ukraine with the support of the Venice Commission since the adoption of the 1996 Constitution was accompanied by repeated attempts both by external forces and their internal allies in Ukraine to turn Ukraine away from the European vector of development, and the number of examples given above, and they are present in my paper, some more examples on that, prove that. And in the end, it allowed Ukraine to achieve, albeit an intermediate but significant goal, to obtain the status of a candidate country for membership of the EU. A quarter-century practice and 2 attempts during the rule of Kuchma and Yanukovych to undermine the constitutional structure of state have proven that in Ukraine, the authoritarian model not only does not take root, but it cannot work. Now, that was about the past, and 2 sentences about the future. The future, when Ukraine will defeat its cursed enemy, the Muscovites, and will win the battle for freedom, for salvation from invasion by a neighboring dictator, for the right to choose our own path, for the right to live as a European country, for the right to be part of the civilized Western world. Can we now be sure that the political class who will take power in that future will not be tempted by authoritarianism, even of a light variety? Instead of answering this question, I will make a remark. We must be vigilant so that after Ukraine defeats the external monster, a domestic Leviathan does not take up residence in the home of free and independent Ukraine. Thank you for your attention.
We all wish that you have a bright future. Lawyers are of little help when democracy has to be defended in the battlefield. But I do hope that we all are united in a determination that justice always triumphs. So, now all the key speeches have been given, and we have two reflections on what has been said today about the subject of self-defense of democracy. And the first reflection will be given by Danute Juočiene, President of the Constitutional Court of the Republic of Lithuania. She is also a professor at the Institute of International and EU Law at the Mykolas Romeris University and holds a PhD degree in law. Please.
Thank you very much. Dear colleagues, dear friends, of course it's very difficult to speak after very nice speech of my colleague and friend Sergei Golovaty. And of course I would like just to say in front of all of you that my country, Lithuania, and the Constitutional Court of the Republic of Lithuania is fully supporting your fight. We are always with you from all the sense, including the moral support. And I am very pleased to have here Manola, my good friend, President of the Moldovan Constitutional Court, and also the representative of the Venice Commission here. You know that even within the European Constitutional Court conferences, we were fighting a lot to suspend Russian Federation from the World Constitutional Court conference, but we were not successful in this. And of course, in the framework of this conference, only one question can be asked when we're talking about the threats to democracy: what can be done more by one state in order to be just suspended from the World Constitutional Court conference? If military aggression against independent state is not enough, then I don't know what can be the ground as a ground for suspension of the state from this international conference. But for this reason, Lithuanian Constitutional Court decided not to send a delegation to Bali, because this is our, to some extent, opposition towards such developments going on in the World Conference of Constitutional Court. But now I turn to our conference. And first of all, I would like to congratulate the Constitutional Court of the Republic of Latvia with the 100 years anniversary of the Latvian Constitution. And I wish the state of Latvia, being always, I cite, democratic, socially responsible and national state based on the rule of law and on respect for human dignity and freedom. The end of quotation. And I also wish the people of Latvia, being always capable of protecting, I cite, their sovereignty, national independence, and democratic system of government of the state of Latvia. End of quotation. So I rely on these words coming from the preamble of the Latvian Constitution that to some extent reflects our today's discussion about democracy. And now I turn to my comments. I would like to highlight only 4 aspects. Of course, it's not my presentation I sent to the organizers of this conference. First of all, I would like to refer to the phrase used by my friend and colleague, judge from the German Federal Constitutional Court, about the protection of foundation of democracy. And here I would like to speak from the perspectives of the Lithuanian Constitution. In the Lithuanian Constitution, we have Article 1 of the Constitution, which describes that Lithuania is an independent state, independent democratic state, and a ruling form of Lithuania is a republic. So in principle, these three elements, democracy, independence, and republic, is so-called eternal values of the Constitution of the Republic of Lithuania. Constitutional Court, when interpreting Article 1 of the Constitution, has fixed very clear safeguards and standards concerning these fundamental constitutional values. One of the most important aspects is that according to the official doctrine of the Constitutional Court, these foundations of the Lithuanian state, these eternal values can never be changed. The Article 1 of the Constitution can even not be changed by the referendum. So here we have some, in principle, limitation as regards the free will of people, as mentioned by His Excellency President of Latvia, Egils Levits, and also my colleague from European Court of Human Rights, Pauline Koskelo. So Lithuanian Constitutional Court has clearly stated that these eternal values cannot be changed even by the referendum of Lithuania. It means that already in 1922 selected direction of the Lithuanian state to be an independent state, to have a ruling form of the republic, and to be a democratic state cannot be changed anytime. Now I turn to the second aspect, which was discussed today very deeply. Of course, this concerns the protection of fundamental rights, which is my loved subject all the time, taking my background in the European Court of Human Rights and my PhD about the application of the Convention at domestic level. And here, of course, in today's discussions, I found to some extent some contradiction or some different ideas which have been raised during the discussion. His Excellency President, when talking about private life and protection of personal autonomy in digital age, speaks about fixing a new standards which should be fixed in legislative framework, or even better by the constitution, by the constitutions of the state. And of course, according to Mr. Egils Levits, this should be done only after very free or open public discussions with the society. Of course, my question is how to do it. But okay, this is a polemic question. I think everybody can intervene into the discussions. On the other hand, Judge Paulina Koskelo from European Court of Human Rights was telling, if I understood correctly your point, that we have in principle already standards of human rights protection fixed. But the courts, of course, ordinary courts, constitutional courts especially, and of course European Court of Human Rights, can refix the standards already existing, or even to reinterpret some provisions of laws. And of course, I think constitutional court judges know quite exactly what does reinterpretation of some official constitutional doctrine mean. And here I turn to my colleague who is passed away this summer, and Latvian colleagues knows him. It's Gediminas Mesonis, professor of constitutional law. He passed away very, very young, and he was always telling that reinterpretation of some constitutional official doctrine is one of the most difficult tasks for the Constitutional Court, because it's like a choral, and then you have to find another choral to be added to the main choral. So this is very nice interpretation of this constitutional, let's say, doctrine concerning the reinterpretation of the constitutional doctrine, which is not so easy at all. And Lithuanian Constitutional Court has very, again, important safeguards as regards the reinterpretation of the constitutional doctrine. But coming back to the human rights protection, talking from the perspectives of the Lithuanian Constitutional Court, then in principle I have to highlight three aspects. First aspect is that we are very much, especially now, developing the idea of dignity of person. And here, of course, I have to confess to my German colleague, we are taking some ideas from the German Federal Constitutional Court. For this reason, we wanted very much to have our bilateral contacts with German Federal Constitutional Court. Second aspect, which is very important when we speak about the protection of human rights under the Lithuanian Constitution, is that we have clearly recognized that European Convention on Human Rights and European Union law, including the Charter of Fundamental Rights, in principle are regarded as a minimum protection, minimum standards for human rights protection under the Lithuanian Constitution. So it means even the European Convention on Human Rights and European Union law in principle are regarded as a source for interpretation of the Lithuanian Constitution in human rights field. It means that we are in principle always following the international court jurisprudences in the human rights interpretation, but we are leaving for us discretion to provide higher standards when it's needed according to the wish of the Constitutional Court. This is, I think, very important aspect. And third very important aspect that Constitutional Court has clearly stated in this official doctrine that Constitution is anti-majoritarian act and Constitution protects everyone. And especially these questions are very important when we are speaking about people, LGBT, let's say people, about the right of the same-sex couples to receive the residence permits in Lithuania and so on. In these cases, the Constitutional Court of the Republic of Lithuania directly referred to the Court of Justice of European Union and many, many cases of the European Court of Human Rights on this field. Of course, when talking about human rights protection from the perspectives of this conference, when we speak about the democracy, I think very important question which had already been raised, not only today, but in many discussions before, it's of course COVID-19 pandemic. And the main question for the Constitutional Court was, and for my court as well, whether we have to, in reality, to go to the classical fixed standards for human rights protection, let's say to go to the so-called classical test of limitation, legality, necessity, and proportionality, or we have to fix some specific, let's say, constitutional standards for pandemic issues. And of course, this question in principle remains open, and for the Constitutional Court, of course, I hope that we will select the first classical way. We will go for the classical test of balancing of human rights, limitation of human rights, but we have still some cases pending. For example, one of the cases also, which can also be regarded as related to democracy issues, about the right of Lithuanian people to return back to Lithuania. Because, of course, now the question is that if you have a positive test of COVID, you cannot return to the country. And then the question is whether the absolute right is not violated according to the Constitution. And of course, there are many other cases pending for to be decided by the Constitutional Court. So, of course, I would like to stop talking about human rights because I have not so much time left. And then my third and fourth aspect is, which was also discussed today, it's calling and organizing of referendums and, of course, election rights, which are very important for the democracy in the states. Here, I would like just to state that Lithuanian Constitutional Court has fixed very interesting material and substantial requirements for calling and organization of referendums. Of course, again, we have no time for deeper discussions on these issues, but, for example, the Constitutional Court of the Republic of Lithuania stated that for referendum, the questions only related amongst themselves can be put. You cannot put totally different questions to be decided by one referendum. Another aspect was whether, for example, the referendum can be organized in 2 days within 2 weeks of break. And the Constitutional Court stated that this is not in line with the democratical standards and with the transparency of the referendums. Election rights, of course, election rights are very important. And for example, again, I return to my German colleague presentation. You were speaking about equal opportunities for political parties. In Lithuanian Constitutional Court, we had very interesting case where a bit different aspect was raised, which is very much related to the democracy issues. It was the question about the equal opportunities to participate in the parliamentary elections for political parties and public committees. Because in Lithuania, it was very stupid limitation for the public committees when participating in the election, passive right, like to be elected, that these committees could participate in the elections only according to alphabetical letter which was assigned to them by the Electoral Commission. So not by the name of the committee, but only by this assigned letter. And in this case, the Constitutional Court decided that, of course, such unequal opportunities for the political parties and for the public committees to participate in the elections, of course, are disturbing the transparency of the Constitution. And fourth aspect, last one. Fourth aspect is that Lithuanian Constitutional Court is very, how to say, known for the impeachment proceedings. Impeachment proceedings, we have a special competence in the impeachment proceedings. And here, of course, I think impeachment proceedings, in my opinion, are directly tool which can be used by Constitutional Court and later on by the Parliament for final vote when defending democracy in the country. And of course, my case, which I wanted to mention here, is 2004 impeachment case when the president of the state, for the first time in the history in Europe, was dismissed from the position for the gross violations of the Constitution and the oath given to Lithuanian state. And here, of course, I refer to my good friend's presentation, Artur Skuč, when he spoke about Ždanoka case and about young democracy in Latvia. Paksas versus Lithuania case went some years after to European Court of Human Rights, and in this case, European Court of Human Rights found a violation concerning the limitations for impeached President Paksas to participate in the parliamentary elections, but also, as Artur referred to Ždanoka case and Paksas case, it was also stated that Lithuania, as a young democracy, in principle, is able or could take some measures to protect the democracy and democratic governance in the state. Sorry for my delay, but of course, I can speak even more.
No. Thank you very much. Thank you for Danute Jociene. And the last remark will be made by Jiří Zemanek, Justice of the Constitutional Court of the Czech Republic. Among others, he has devoted his professional career to teaching and research in the field of international and European law. I'm begging you to make your speech as short as possible, but no longer than 5 minutes. Thank you.
Thank you. Mr. President of the Republic of Latvia, Levits, dear presidents of constitutional courts participated in this conference, dear colleagues, ladies and gentlemen. It's a pleasure for me to be here today on the occasion of 30th anniversary of the Constitutional Court of Latvia and 100th anniversary of the Constitution of this country. We are witnessing a certain breakdown of national democracies when the parliaments are marginalized by de facto forces of the executive branch of the government and by non-state actors occupying the public discourse. On the other hand, democratic majorities sometimes abuse their lawmaking powers on the detriment of the rule of law and fundamental rights of individuals. In both situations, the constitutional review may be called up to resolve the clash between the acts of public power of the day, incorporated in statutes, and the timeless values codified in constitutions. The constitutional review of the acts which reflect at the national level democratic legitimacy deficits existing at the supranational level cannot be avoided too. The Czech Constitutional Court has adjudicated some path-breaking cases dealing with the topic and having an eminent importance for the future. Liberal democracy means that democratic majority is in using its power, among other, in making interpretation, application, enforcement of law subordinated to enacted, eternal, inviolable, fundamental, substantive, suprapositive values. In Article 9, our Constitution is called Essential Requirements for a Democratic State Governed by the Rule of Law, which prefer win-win solutions rather than zero-sum ones. These values are shared not only within a state, but in external dimension as well. So my comments concerning the key speakers is that more emphasis on this external dimension would be willing. So this means that these values are shared by the states which are forming a collective power, even when only in material way of the word, not in formal one. The state acting in this multi-level community should be open and cooperative towards the other participating subjects. Czech Constitutional Court in 1993, in judgment Lawlessness of the Communist Regime, rejected former rational legitimacy of old laws in a constitutional state based on discontinuity in values, sovereignty of the people, and respect to the principle of legality, not neutral in terms of the governing ideas. The reason of liberal democracy is not that everybody may encroach upon anything, but a clear assignment of responsibilities entrusted by the people who can appeal justice when enforcing their claims resulting from such entrustment on equal basis. Rules of the game are fragile. The commitment of public power, of lawmaker as well as administrative and judicial constitutional review to guarantee the equal access to justice for everybody should have to reflect militant democracy, as was said repeatedly today in the morning. A delicate balance between the protection of fundamental rights and cases in which the rights can be sometimes sacrificed in the interest of prevention of misuse of the threats to democratic order, however, without losing its identity. As Václav Havel, our former President of the Republic, said, he pointed out just this aspect, the balance between both the rights and limitations which are necessary in extreme cases in favor of protection of public interest, public values. At least one example at the end of my short speech could be added here. Czech Constitutional Court in November 2011 passed a judgment on national resistance movement, a political-like party, and ruled that criminalization of the promotion of this political movement is not unconstitutional, not contrary to plurality of opinion, to free competition of political forces, to prohibition of discriminatory treatment. When there's protection of political minorities doesn't exempt the democratic state governed by the rule of law and not bound by any exclusive ideology from its duty to suspend under the principle of proportionality and within the limits of law some of its basic principles: freedom of speech, freedom of assembly, and so on. The general context of the case, including its localization in terms of place, time, and way of manifestation, is of importance to the court said. So I could continue with more cases, but I'm afraid there is no time for me much more. And if some discussion will still continue, I can add a few remarks on this aspect. Thank you very much.
Thank you to Judge Zemanek for your reflection on the subject. I'm afraid we are short of time due to next item on our agenda, which is an entertainment, and already the chorus is waiting somewhere. Therefore, you will be able to ask your questions and make your further reflections during lunchtime, and of course I do believe everyone's waiting for the evening gala event where you could and would enjoy further discussions on the subject of self-defense of democracy. Thank you very much for your participation in this panel. And now we are asked to take our seats in the audience for the next announcements. Thank you.
Honorable judges and distinguished guests, after dynamic discussions about sustainability of democracy, we will continue with our special musical performance of the treasure of Latvian culture, one of the world's most famous choirs, youth choir Kamēr. Three-time champion at the World Choir Olympics and European Grand Prix, winner of 6 national competitions in a row. In recent years, Kamēr has developed its own commissioned programs. The principal conductor and artistic director of the choir is Jurģis Cābolis. Today the choir will be conducted by Patriks Kārlis Stepe. We will listen to compositions like Eric Whittaker's Leonardo Dreams of His Flying Machine. What kind of music would fill the mind of such a genius? The drama would tell the story of Leonardo being tormented by the calling of the air. Te Deum, the Pearl of Organ Music by Pēteris Vasks, the most internationally recognized Latvian composer. It will be performed by Digna Markule. Currently, the most relevant Latvian classical music composer, Ēriks Ešenvalds, combines a Latvian folk song with observation of the Northern Lights by 2 19th century Arctic explorers, Hall and Nansen. Latvian folklore, for example, tells that the Northern Lights are the restless spirits of fallen warriors, still fighting their battles in the sky. Finally, the fragments of the new composition about the creation of the world, of the new world, written by Rihards Dubra, specially for choir kamar this year. It will be performed by the choir and organ only for the third time in history. Dear colleagues, after the musical performance, all conference participants are invited to take a family photo here behind me. After that, we will go for lunch together on food. Let me also remind you that the panel discussion number 2 will start at 3 p.m. But now please enjoy the performance. I invite to welcome the Youth Choir Kammer with loud applause.
Sure, Kamal. And now, Excellencies, honorable judges, ladies and gentlemen, I invite you to make an official conference photo right here in the middle, in the center.
Godātie
Dear colleagues, we resume the proceedings of the conference. I'm very honored to introduce to you the key speakers of the second panel discussion, Inet Ziemele, Judge and President of the Chamber of the Court of Justice of the European Union, Kerdis Kierulf Torgeidsdottir, Vice President of the European Commission for Democracy Through Law, or as we know this commission, the Venice Commission, and Irēna Kucina, Vice President of the Constitutional Court of Latvia. And as part of this panel discussion, we will have also our colleague from the Supreme Court of Estonia, Justice and member of the Constitutional Review Chamber, Heiki Lot. He will also be speaking to us, and Andrej Abramovic, Judge of the Constitutional Court of the Republic of Croatia. And this panel discussion will be chaired by Kristaps Tamuš, who is the head of the legal department of our court. So, Kristaps, please, you have the mic now. Thank you, Mr. President.
Dear participants of the conference, good afternoon, honorable speakers. It's a great pleasure for me to be able to moderate this second panel, which is dedicated to sustainability of fundamental rights, with a special focus of adopting fundamental rights to the age of modern technology. We are celebrating 100 years of the Latvian Constitution. However, the human rights chapter of the Latvian Constitution was adopted only 24 years ago. On the other hand, we're also talking about the European Convention on Human Rights, which was adopted 72 years ago. And then we have colleagues from France, whose human rights instrument was adopted in 1789. All these instruments are still applicable and in force with only slight alterations. So the question is, how is it possible? And we are justifiably proud of our Constitution being adaptable to the time by means of living document doctrine. So the question is whether the living document doctrine will help us when we meet with new obstacles. So one of the new obstacles might be the modern technologies and the human rights that might not be adapted to the needs of modern technologies. For instance, this morning, the President of the Republic of Latvia mentioned the possibility that by means of modern technologies, one could influence the free will of persons. That might be certainly a threat to human rights. Or what about the fact that there are possible threats to human rights that derive not from a classic state individual dimension, but they derive from large players such as social networks and Google and whatnot. How about the fact that the existing rights might be simply insufficient for this new environment of human rights? On the other hand, we also have to talk about the fact that the internet is also extremely beneficial for fostering human rights in terms of enabling freedom of speech to unprecedented amount, and it is highly beneficial for many other human rights, such as the right to property, right to a fair trial, and many more come into mind. So the question is whether the dynamic of interpretation of human rights should be moving upwards, downwards, remaining the same, or something in the middle. And then a further question is who is in control of this process? And of course it is the constitutional courts who are mostly in control of this process, and therefore we are very lucky to have these honorable speakers on our bench. And we'll hear their thoughts about whether the existing human rights protection system has run its course and has met an obstacle which now needs to be overcome by some other means, or whether we are still fine and we can rely on the constitutional courts to continue to interpret the existing human rights catalogs as they are. I will now give the floor to the first speaker of our panel, and that is Professor Judge Ineta Ziemele, who is the former president of the Constitutional Court of Latvia, former judge of the European Court of Human Rights, a section president of the European Court of Human Rights, and currently a judge at the Court of Justice of European Union. She is also a professor at the Riga Graduate School of Law, and she has published probably more extensively than anyone in Latvia on human rights and interaction between human rights and international law. So, Professor Ziemele, the floor is yours.
Good afternoon. Dear President of the Constitutional Court, the presidents of all of the other courts, and the judges, and ladies, gentlemen, and the friends. It's such a pleasure, actually, to see you all, some of you again, back in Riga. Some of you were here a year ago and have participated in many other events that throughout 25 years, the Latvian Constitutional Court, in fact, has been trying to organize this European-wide debate, and I'm very proud of that as well. And indeed, I'm very proud of the fact that with such an international event, we celebrate 100 years of the Latvian Constitution. And you've heard a lot about it already today, and there is a lot of interesting reading also by the colleagues, judges, available also in English about Latvian Constitution. So it's worthwhile to take a look, because 100 years, that's quite a story, actually, for the country and its constitutionalism. Now, however, this time around, I have been asked to talk about sustainability of human rights, indeed, in this digital age. And Mr. Tamas put all of the relevant questions in front of us, and actually we do know these questions already. I have been trying to conceptualize our responses to various risks in some of my previous speeches, still in a capacity of the President of the Constitutional Court. I had the pleasure to share some of my thoughts with the Slovenian Constitutional Court when we celebrated your Constitution Day. And today I decided that I would probably offer you sort of a bigger conceptual view, at least one possibility, how to look at what the world, you know, the circumstances in which we live today. And I hope at least the perspective that I'm going to offer to you might catch your attention, and we could discuss it further. So, we all agree that rapid developments in science and technologies have affected our lifestyles. It is sufficient to compare the way we communicated only 25 years ago with current century to see that difference. There are a lot of advantages. Intense human interaction has been more enabled, and there is more potential for transparency and expression. There are, however, evident risks. Internet is a tool with many sides to it. The real question is how the humanity uses this tool, for what reason and for what purpose. It is important to recall that on 1 July 2016, the United Nations Human Rights Council adopted Resolution 3213, the promotion, protection, and enjoyment of human rights on Internet. Following the resolution, the international headlines carried the titles that the United Nations has recognized the right to Internet as a human right, and the governments now have to ensure that everyone has access to Internet, because where there is a right, normally there is an obligation. However, the resolution does not take such a view. Conceptually, the Human Rights Council sees internet as a tool and as a new space for human interaction within which human rights have to be guaranteed same way as offline. The position of the Universal World Forum on the issues we are debating today is summed up in the resolution as follows. First, the same rights that people have offline must also be protected online, in particular freedom of expression, which is applicable regardless of frontiers and through any media of one's choice, in accordance with relevant articles in the Universal Declaration of Human Rights and International Covenant on Civil and Political Rights. Second, the global and open nature of the internet is a driving force in accelerating progress towards development in its various forms, including, and I start to emphasize, in achieving sustainable development goals. Third, quality education plays a decisive role, and therefore all states have to promote digital literacy and to facilitate access to information on the internet, which can be an important tool in facilitating the promotion of the right to education. Finally, a comprehensive human rights-based approach in providing and expanding access to the internet is important. In other words, the internet is a tool that enables the enjoyment of human rights and fosters sustainable development. The states certainly now have more tools, and individuals as well, but also more responsibility. Today we are discussing whether, even if many patterns of human behavior have changed or are changing due to technologies, the intellectual frames which have organized our lives as individuals and societies so far are still sufficient to embrace the progress in science and technologies, or new laws, new methodologies, especially as far as courts are concerned, are required. So today's conference that marks 100 years, so it's a seemingly a rather grown-up constitutional frame. Today's conference also asks the question whether the digital age presents risks to sustainability of fundamental rights. And it is in this sense that these risks, in fact, call for a possible action. Well, I think it is important to recall that history shows that progress has always been full of risks, and we indeed, because of some hard experiences, have only subsequently developed new principles, have taken new decisions, have created new rules. It is therefore that I personally think there is absolutely nothing wrong for humanity to regularly, periodically review whether the existing intellectual frames, whether the values that we are used to are still the right ones, the valid ones. I call it actually that, I say, it might sound rather harsh, but I say regular stress tests to our constitutional orders, in fact, prove to be rather useful. I would like firstly to concentrate on the idea of sustainability of fundamental rights and provide some explanations since, you know, in international law, this is the topic that has been debated for some decades, and as we know, United Nations has indeed played a major role in this debate. But secondly, I will address the question that interests, seems to be, everyone in the room, whether judges have sufficient tools to ensure sustainability in the digital age. And I will draw on some of the examples, in fact, of the Court of Justice and also Latvian Constitutional Court. Now, we should always start from the beginning. And actually, that is the point where did the discussion on sustainability, on sustainable development started. Now, in international law, I would like to draw your attention to recall that the United Nations General Assembly adopted Resolution 4128 on 4 December 1986 on the right to development. And let me give you Article 1 of that declaration. The right to development is an inalienable human right by virtue of which every human person and all peoples are entitled to participate in, contribute to, and enjoy economic, social, cultural, and political development, in which all human rights and fundamental freedoms can be fully realized. It is important to recall that the UDHR does not have an independent right to development as a subjective human right. But it has an idea of development. For example, the right to education implies that it shall be directed to the full development of human personality. Now, on Universal Declaration of Human Rights, very quickly, you will, we all know that the UDHR places in the middle of our worldview human dignity. And it is from that paradigm that the whole human rights law development in the 20th century has departed. There was a reason for that, as you know. 2 world wars led the world consciousness to say that it is of absolute paramount importance that to recognize that a human being is a value and that every human being has to be respected on equal basis. Now, this, of course, still remains our main organizing idea, even in the digital age. And this is very important to recognize, that maybe some of the difficulties that we have today to harmonize the digital age and our paradigms is precisely that. Because, by all means, we would like to ensure that human dignity, the way we have come to understand it in the 20th century, is respected, even, in the very changed circumstances. Now, we might have maybe underestimated during the 20th century another very important aspect, which has always been there. The fact that individual choices and individual behaviors, in fact, affect the world around them. And it is this contextual paradigm that maybe has been somehow left in the second place. And I'm actually going straight into it. There is one article in the Universal Declaration, Article 29, that I remember from the 20th century that has not been particularly liked, certainly in some of the Western legal thinking and political philosophy. And Article 29 says, everyone has duties to the community in which alone the free and full development of his personality is possible. And I will remind you that the Declaration on the Right to Development and the conceptualization of the right to development actually was very controversial. In the United Nations, you had groups of states saying, well, we don't need the right to development because we have individual rights. And if those are respected, then that's enough. And then you had the group of states from the third world saying, no, we need right to development, mostly thinking that we need the aid from those that are more rich, while individual rights were not necessarily embraced. So it's been a very difficult, we should not lose sight that getting sustainability concept into the mainstream human rights thinking has not been an easy road. Now, however, the thinking on the right to development as a human right and a comprehensive economic, social, cultural, and political process, I quote, which aims at the constant improvement of the well-being of the entire population and of all individuals on the basis of their active, free, and meaningful participation in development and in the fair distribution of benefits resulting therefrom, represents, I argue, a certain shift from an exclusively individual-centered perspective to what I would really like to call a more holistic view of human rights, which embraces global interconnection, and that's the language that is used in the Human Rights Council resolution. In the digital world, what the Declaration on the Right to Development already saw, in my mind, is actually confirmed. It is therefore, and for good reasons, that the Human Rights Council resolution embraces the adoption of the 2030 Agenda for Sustainable Development and recognizes that the spread of information and communications technology has great potential to accelerate human progress, to bridge the digital divide, and to develop knowledge societies. And so the holistic view of human rights has slowly consolidated over time, and certainly the 1986 declaration, to me, was an important point in that development. And the recognition of the shift, I think, a certain shift within our intellectual paradigm is reflected in the key General Assembly Resolution 71 of 25 September 2015, named Transforming Our World, the 2030 Agenda for Sustainable Development, which resolution explains the evolution of understanding of the modern challenges humanity and the planet faces and responses that we so far have come up with. And so what the General Assembly resolution on sustainable development says, it says, well, all of what we have developed, starting from the United Nations Charter, and the peaceful context is extremely important for development, as we know, going through all of the human rights instruments, mentioning the Right to Development Declaration, the Rio Declaration on Environment, the World Summit on Sustainable Development. I mean, there have been many, many actions, as I mentioned earlier, within the United Nations context. And so it's been a important progression towards what now the GA resolution calls integrated, to achieve integrated solutions. And indeed, the General Assembly says a new approach is needed. I will not go through the 17 Sustainable Development Goals and 169 targets. I will just sum it up for you in a very simple way. You see, it is evident that we need a global approach. One cannot, what we have seen so far is if there is one part, one continent on the planet that more or less manages to have, you know, strong economy, sort of equality within the societies, that one continent alone will not do, because there are other parts of the world where that economic development is not so strong, and certainly if there is economic development, there are no necessarily environment-friendly, for example, methods in a way of doing business. So this recognition of interconnectedness is not only for international judges, but also for national judges, a very important paradigm to keep in mind. And yeah, that is a certain shift if you are looking from a national point of view. Now, it is after sort of when looking at these developments at an international level, what I can say is that the sustainability of fundamental rights is certainly not challenged by the internet as such. To the contrary, internet accelerates, hopefully, our understanding of how interconnected we all are. And I think it has the capacity to build, to tell us that we need to engage in a new type of responsibility as a humanity and in the interests of the planet. So it is this thinking that is now, I think, very important in human rights law. Before I go to my last part on the role of the courts, I am really skipping pages for the sake of the translation. You see, the point I will be making is the following. The national courts, as well as international courts, already now can engage in this kind of a holistic view of human rights, in a paradigm shift, where we do think about sustainability of the planet and all human race. Now, however, before courts get to that thinking, as well as the societies, it is important to, in fact, take stock of the values, of our understanding of the values that matter to us. You do all know that, of course, Article 2 of the Treaty on the European Union also says that the European Union is based on our common values. Nevertheless, we are all engaged, as the Court of Justice, as national judges, all engaged in concretizing and explaining Article 2. So what are these common values of us as a European Union, those of you who are the EU judges here as well? So it is not so obvious when you say democracy, rule of law, human rights, to actually agree on the hardcore and maybe the margins. I would like simply to throw in another sort of reflection in our legal and philosophical thinking of the 20th century. We do know that there are voices already for some time that are seriously concerned about what these voices call as excessive importance attributed in our Western societies to materialistic values, wealth, property, prosperity, individual comfort. And these voices are seriously concerned about the other set of values that are linked with, you know, the philosophy of humanism in a broader sense, such as equality, dignity, responsibility, as well, empathy. And there are voices saying, well, the second set, if you want, is on decline. I really think that it is this choice, when we raise the values, that has to do with sustainability. It is the choice that we make among the values, sometimes we have to do that, that then answer the question where we see, you know, the sustainability of our nation, of our community, of our planet. I would like to mention to you, there is a most interesting, very recent book along these lines, and the name of the book is Quo Vadis, Western World. And that book is written by the Latvian Archbishop of the Catholic Church, Zbigniew Stankovic. Unfortunately, it's only available in Italian and Latvian. But it's a very, very interesting read, and one of the things that our Archbishop does, he reminds of Alexander Solzhenitsyn, who actually, we may all imagine, already some decades ago said the following: "Today we witness the triumph of materialism, the fading of values of humanism, and I find this situation horrible. I believe if humanity is not doomed, it must renew its set of values. For example, spiritual values must be more important than material well-being," one of the voices. Now, the question on the role of constitutional courts in the digital world can really be narrowed down to the question whether the courts have anything to do with upholding the values and also making choices, as the case may be. Or are we really only in the business of a rather narrow application of laws passed by legislator? This question is not new, I know. Sometimes it has been posed differently when asked whether the so-called activism of courts is legally permissible. I argue that this question, which has characterized the 20th century dominant legal discourse, legal positivism, is by now outdated. Sustainability of each nation is the very reason of a state and its institutions, including the courts. It is therefore that when assessing the constitutionality of laws, the constitutional courts today have to engage in weighing the constitutional values in a way that leads to sustainable development of a nation and the world. Especially, of course, first cases that most of us have already dealt with are the cases relevant to climate change, and I will actually now come to some examples. You know, I would like to emphasize, and the first president of the Latvian Constitutional Court is here, that the choice Latvian Constitutional Court made already in 2007, when it decided on the basis of Article 115 of the Latvian Constitution to allow an NGO to bring a constitutional complaint to the Constitutional Court, because that NGO was not part of the deliberations process on the development project, but it was an NGO with a purpose to protect environment. In 2007, that was a sustainability choice. Now, in fact, 10 years later, the Constitutional Court with another NGO concerning the Cabinet of Ministers regulation on CO2 emissions, and that is a very important area of EU law, and we have many, many cases of states violating the EU regulations, and therefore there are proceedings for violating the law. Now, unfortunately, the Constitutional Court in that case in 2016 considered that the NGO, probably this NGO, should not have the legal standing in such a case. At the moment, the Court of Justice is deliberating a very important case as far as Germany is concerned, in exactly the same, and that's why I'm late for the conference, because we deliberated still yesterday until late evening. And it is about the legal standing. You know for what? The question is whether environmental NGO should have a standing to bring proceedings on the basis of EU regulations concerning diesel engines, where there is an incompatibility of diesel engines with the EU regulations. Should such NGOs have a legal claim in the German courts? That is the question. This is the example of extremely important weighing and choices. We will see how it evolves. Another example of the Latvian Constitutional Court has to do with the gambling halls. There are two cases, and one is taken recently in the context of COVID-19, and I would like to quote it, because here is a very important statement of this court. Now, The court explained, in fact, here the court engaged in exactly what I was telling you. It was the question about materialistic values on the one hand and the broader values of humanity. And the court actually sees that confrontation, in a way, exactly in this way. So the court explained, what is more, along with aspects of material welfare, the notion of public welfare includes also non-material aspects that are necessary for harmonious operation of society. Individual and public health is a value that plays a distinct role in ensuring public welfare in both in its material and non-material aspect. Specifically, public welfare is to be considered from both financial and, as it's translated from Latvian, universal perspectives. Now, it is here that the Latvian Constitutional Court hints that even if it understands the importance of money, there are other, possibly more important values, and engages in weighing and finding, in this case, a harmony between the two. And I must say, I'm really, really interested to see what the court will do next, because now the court has a basis to develop further what it has named as universal perspective. In other words, sort of the values of humanity. Now, in the same domain, it is to be recalled that as far as gambling is concerned, Court of Justice has rather considerable case law. And in fact, the Court of Justice, in those states where the gambling houses are monopolized, it's a very heavily regulated area, in my mind, for good reason. And so I'm in the right court in that context, because the Court of Justice has said that the monopoly is in compliance with one of the four fundamental freedoms of the European Union, for the freedom of establishment. I can tell you that for the Court of Justice to accept these types of restrictions on these four freedoms is not an easy matter. So to accept that monopoly is okay, that might have to do with a bigger picture. Now, another example, you will be surprised, consumer protection. Why do you think the choice made from EU legislator, of course, but the court interpreted the rights of consumers in such a, those of you in this domain, in such a consumer-friendly manner, instead of giving all the shots, with all due respect, to the banks and financial operators? It is a very consumer-friendly approach. That's also an interesting choice. Now, these are choices, and I think the case law shows that the choices are being made. And it is very important to keep the paradigm of sustainability in mind. It is therefore that I argue a court can and must engage in sustainable development assessment. Actually, the Fundamental Rights Charter has the sustainable development principle in Article 37, just as we speak. So the court must look at it, either when it looks at the quality of legislative process, either when it looks at the analysis, when it examines the legitimate aim proposed by the legislator, and finally, of course, and that will always be there, when we assess proportionality and the alternatives when restrictions are proposed. It is this shift of paradigm that should be really on our minds. Now, all courts with jurisdictions to make a reasoned choice as to which human right or freedom prevails in each case are with a potential to engage in a holistic and integrated application of rights. where the court, for example, gives reason to equal rights and therefore sides with an inclusive view of the society, that approach certainly is in line with the United Nations sustainability goals, which mention inclusiveness as one of the fundamentals for the sustainable world. Now, there is a line to be drawn with Actio Popularis. I know it very, very well. I will not go into it. I will just say the following. In the context of sustainable development, I think Actio Popularis concept, as one of the organizing concepts of the 20th century, I should say, but it is this concept that really needs an important intellectual review if we are serious about our future. In fact, in the case we are deliberating right now, Deutsche Umwelthilfe case, you know, that also is an argument raised evidently about Actio Popularis. Finally, what we have seen so far in the specific area of fundamental rights and the internet, especially as reflected, for example, in the case law of the Court of Justice recently on data protection, is about making choices among the values and protecting them. The Court of Justice has insisted that the protection of data and privacy remains fundamental to the worldview, and in fact, it is through this perspective that the Court of Justice sees sustainability, the future of the society. Human beings need space, we need privacy. As you know, in the cases such as Quadrature du Net, the governments, of course, very much benefit from all of these technologies, and there are, of course, some oftentimes legitimate needs to restrict these rights. So what the court does, it lays down the detailed algorithms that the governments must follow when they decide to engage in restricting privacy. And it is in these cases, I argue, that the Court of Justice, weighing security, but actually on the other hand, weighing the importance of privacy, and in the end, sustainability of humanity. These are the cases. So I think I have showed that we have enough intellectual tools, answering all of the questions of Kristaps, to make the right moral choices that are aimed at preservation of the humanity and our planet. I think the key is awareness and willingness. And I thank you for your attention.
Thank you very much, Judge Zemele, for your extensive and detailed presentation, which ended up on an optimistic note that we already have all the tools that are necessary to deal with modern challenges, including technological challenges, and those tools are in hands of the judges who now are here to enrich each other with their ideas. Next speaker will be Ms. Herdis Kjerulf Torgersdottir. Was it okay? I practiced. She's the Vice President of the Venice Commission, and she's a lawyer and a political scientist, and she has been a professor of constitutional law, and she has done extensive research on freedom of expression, the media, democracy, and human rights, and that's probably one of the big reasons why we would like to hear what you have to say on the topic. Thank you.
Thank you very much, Mr. Chair, and thank you, Ineta, for an excellent speech, contribution, excellent. Mr. President of the Constitutional Court, honorable judges, distinguished participants, I'm honored to be in Riga, the city with a center that is a living illustration of European history, to celebrate the 100th anniversary of the Constitution of Latvia, which is one of the oldest republican basic laws in the world. And I also want to congratulate the judges of the court on the 25th anniversary of the Constitutional Court. We are gathered at a time of deep crisis for democracy and human rights. A major war is taking place in the midst of Europe between, until recently, 2 Council of Europe member states, states which incidentally the European Commission for Democracy through Law, better known as the Venice Commission, was created to assist. At a time of radical political change in Eastern Europe some 30 years ago, with a task of providing emergency constitutional aid to states in transition. The idea to create a European Commission for Democracy through Law was based on the theory that sustainable democracies could only be built in a constitutional framework based on the rule of law and human rights, where the European Convention on Human Rights remains the ultimate benchmark throughout the Council of Europe member states without any exception. As my focus here is on the challenge to protect an internet that promotes democratic values, translating freedom of expression, and hence the possibility of a robust political debate into the digital environment, a robust public discourse, the words of a Russian politician a decade after the collapse of the Soviet Union may be recalled. He thanked the factual information about Soviet society for paving the way for the end of communist dictatorship, emphasizing the power of information as a tool to transform totalitarian regimes into a more democratic ones and more responsible and reliable members of the international community. This was at a time when Russia and the rest of the Eastern Bloc had joined the Council of Europe, optimism was growing, and these countries were seen as valuable allies of the West. To quote President Putin in 2001, the Cold War was over and the world in a new stage of development. They had become parties to the European Convention on Human Rights, embracing formally the civil and political rights underlying democracy, not least the touchstone freedom of expression, opinion, and information. However, the respect for freedom of expression has dramatically declined in Russia in the last decade. Censorship has taken on a new significance online with regressive laws like the so-called sovereign internet law in 2019, passed, which allows the government to cut off the internet completely from traffic outside Russia in an emergency. It requires internet service providers to install software that can track, filter, and reroute internet traffic. And such technology allows the state telecommunications watchdog to independently and extrajudicially block access to content that the government deems a threat. The technology could also allow this telecommunication watchdog to slow down specific internet services without the users knowing, including YouTube, Facebook, etc. Repressive laws and policies restrict online speech and stifle critical voices. The ongoing war in Ukraine has exposed the crucial need of uplifting the voices of the opponents of the regime and for enabling a political discourse to take place among the citizens. Another interesting aspect of internet legislation in Russia recently is the so-called social media self-censorship law from February 2021, which places the burden of deciding whether an online post is potentially illegal upon the tech companies themselves, skipping the intervention of the telecommunications watchdog, creating, hence, fertile ground for violating the freedom of expression of the users of these online platforms. The delegation of responsibility for policing harmful speech or censoring wrong views to internet companies with often opaque and inconsistent practices is highly problematic, and not just in Russia. Handing huge new powers of censorship to tech giants grants them scope to impact the robust political debate. At the same time, it reinforces state control over online expression. The overall impact will be self-censorship. Fierce debates are occurring around regulatory initiatives aimed at social media companies in democratic countries as well, such as the EU Digital Services Act and the UK Online Safety Bill, to name one, which outsources the decisions on illegality on online platforms or to online platforms. The Venice Commission has warned against unaccountable content regulation and overbroad censorship by tech companies, which will turn them into semi-tribunals, leaving users without any judicial oversight or right to appeal. Internet service providers have human rights responsibilities towards their users. Yet social media sites have already implemented their own content moderation policies under which they remove certain content. And the Venice Commission points out that in such cases, direct incitement to violence or illegal activity is not protected speech and does not enjoy the protection of Article 10 of the Convention. We live in polarized times, and democracy and the principles that support it must constantly be tested by radically free public discourse. That is why the Venice Commission has underscored that even speech that is at odds with mainstream democratic values must be permitted, as it may contain a relevant political message. We should be mindful of the old saying that the road to hell is paved with good intentions. It is not in accordance with the spirit of Article 10 of the European Convention on Human Rights to let tech giants or governments shape the political debate, which is crucial to sustaining democracy. Distinguished participants, the principle of one global democratic communication network seems a reality that is slipping through our fingers. Given the short time to speak, I cannot touch upon but what I deem to be the major problem destroying the internet as a democratic tool. The internet, the road system for the digital world with a worldwide computer network, the web, it was designed to be an open place where anyone could contribute, where no permission was needed from centralized authority to post anything on the web, no central controlling connection. The democratic promise of the internet was to empower the ordinary citizen, where the public discourse was for the first time no longer confined to political elites or professional media. It was designed to provide a forum for the participation of everyone. A decentralized platform with the potential of information and power to be equally distributed, and the social media promised to give everyone a voice. Over the last two decades, digital platforms have become an integral part of our lives. Amazon, Google, Facebook, they have revolutionized the way people interact and exercise their freedom of expression and information. The online platforms have become really the dominant forums of political interaction in various democracies. Yet, they have also been used to conduct cyber espionage, to spread disinformation and propaganda in order to shape public opinion, commercializing data and seriously threatening privacy rights, as the Venice Commission pointed out in a 2019 report. Hence, the same technology that facilitates the political discourse creates opportunities to censor information and manipulate public opinion. The empowerment of citizens with digital technologies may hence be questioned. The internet platforms allow people to experience the world through a lonely, personalized lens. The political discourse has been removed from the real world to a virtual world, which some describe as a nightmarish inversion of the democratic dream of an open public sphere, as users drift anonymously into digital spaces, into echo chambers, where they are rarely confronted with opposing views. Conversations are governed by rules set by Facebook or other for-profit companies. They are ruled by algorithms designed to capture attention, collect personal data, and sell advertising, and hence the terms surveillance capitalism and data colonialism reflect the inability of users to stop their data from being unwittingly extracted. And there are troll farms with fake accounts operated to spread disinformation. So, after this period of optimism about innovation and the internet, we are now faced with a technology sector that has concentrated rapidly since the beginning of the millennium. A handful of giant tech companies dominate the public sphere. Social media platforms like Facebook, Twitter, and more have gained new, powerful gatekeeper positions. They are in a position to ban or censor whoever and whatever they wish, as well as to design their platforms to encourage and amplify certain content over others, guided by their own commercial and political interests. They are in a position to undermine the foundations of democracy with their overwhelming influence on the public discourse, not to mention collecting and exploiting personal data, and open a window into users' thoughts and cognitive processes. So we are witnessing the same forces at work as in the traditional media landscape, and they are able to reach every corner of the world and transform societies and lives. I know it's not very politically correct to quote the ill-fated Third Reich minister of propaganda, I won't even say his name, who mockingly said that the best joke of democracy is to give its deadly enemies the means by which it is destroyed. An online system controlled by a tiny number of companies is not democratic, it's oligarchic. The rule of the few over the public discourse is both a farce and a tragedy. The Venice Commission detected in a 2019 report the serious challenges of the oligarchic trends of a very few powerful private actors who literally own the internet and whose interests tend to collide with political and civil rights. An internet that is in fact not based on the values of openness, accountability, and respect for human rights is an enormous challenge, and in order to translate the fundamental values inherent in the right to freedom of expression, opinion, and information into the digital environment, the Venice Commission in 2020, when adopting the principles for fundamental rights compliant use of technologies, in particular electoral processes, emphasized the need to protect an open internet and net neutrality, at least during electoral periods. This means that internet service providers must treat internet communication equally. A level playing field must be guaranteed for both users and content providers. Distinguished participants, finally, my last point regarding the problem on how to respond to the powerful position of a few private companies that have global control over the flow of information and are thus in a position to shape the political discourse and opinion formation. The Venice Commission supports the Council of Europe Parliamentary Assembly resolution from 2020 to break up the monopoly of tech companies. These tech companies control to a great extent citizens' access to information and data. The existence of monopolies or oligarchic control of the internet simply does not go hand in hand with democracy and human rights. Distinguished participants, the Venice Commission will continue to work strenuously towards building a human rights compliant environment to promote democratic values on the internet. And allow me to quote Thomas Jefferson, who warned in the early around 1800 that every government degenerates when trusted to the rulers of the people alone. The people themselves are the only safe depositories. Finally, the fight against political or oligarchic power with a harmful mentality to stifle critical voices must never cease. Thank you very much.
Thank you very much, Ms. Torgeisdottir, for your speech, which compared to Judge Ziemele's cautiously optimistic vision of human rights in online world was rather gloomy. But luckily, there were some routes of escape offered to all of us, and hopefully we'll manage to use those. Next, I would like to give floor to our third main speaker, which is Judge Irena Kucina, Vice President of the Constitutional Court of Latvia. She is also an associate professor at the University of Latvia and a member of Board of Trustees of European Rights Academy. And she has published extensively on a number of topics, including interaction between EU law and national law, and in particular problems of rule of law in European Union member states.
Judge Kucinet, the floor is yours.
Thank you so much. Dārgā
Dear family of constitutional courts, if I may address you like this today, dear guests, dear colleagues, before I give my presentation, the main topic of which is access to internet as a tool for promoting inclusive society, I would like to thank the delegation of Ukraine, all of you who are here with us today, who found the possibility to be with us here and to speak to us, and also to be happy together with us. And while being here at this conference, I had the feeling that our Ukrainian colleagues reminded us of what genuine happiness and genuine law and right are that we can feel and enjoy. Thank you very much for this. And now I will give my presentation as intended. The right to internet access. The main issues have already been named, and also the President this morning spoke about it. Whether our fundamental rights safeguarded by our constitutions are sufficient to follow and to not fall behind for the new technologies and to protect fundamental rights, or whether we, as society and as a state and also other states, are we ready to move on and to speak about the need to enshrine this right to internet access in our constitutions? And I will just mention some examples, both of the opinions that such rights should be enshrined in national constitutions. And also I will mention views to the contrary. And then you'll be able to weigh, as judges are doing, what your choice will be. Digitization is one of the most relevant trends in the development of society. It is driven not only by organizations wishing to create new products, services, and to increase their added value, but also by socio-economic and cultural changes, as well as by the impact of external environment. The European Commission has advanced digitization as one of its main priorities, underscoring that technologies and digital solutions should be people-centered and should facilitate sustainability. Digital technologies offer new possibilities and have evolved into one of the main means that persons can use to exercise their right, as we heard already, to freedom of speech or freedom of expression. The content of this right is first of all aimed at expressions of a person's private autonomy and internal freedom. However, freedom of speech is also a value of a democratic state and an essential element of democratic society, ensuring to society the possibility to impact political processes. Democracy evolves thanks to the freedom of expression. Likewise, accessibility of the internet impacts the exercise of other fundamental rights, the right to property, the right to education, and the right to choose one's vocation. States are moving ever faster towards digitization of not only public administration, but also courts, and probably you've seen this already in your practice. Digital technologies, among others, the internet, not only offer new possibilities, but also challenge the existing values, leading to questions, for example, regarding protection of our privacy. If digital technologies are used incorrectly or if they are abused, they may increase insecurity, jeopardize fundamental rights, and exacerbate inequality. The global crisis caused by COVID-19 pandemic outlined more sharply the pronounced need to use digital technologies, also the internet, foregrounding the issue of accessing the internet and the content of human rights in digital environment. Clearly, access to the internet gains relevance in promoting inclusive society, influencing persons' possibilities to participate in the life of the state and society. The Latvian Constitutional Court, our court, has recognized, in order for everyone to lead a life that is worthy of human dignity, a person's possibility to participate in social, political, and cultural life must be guaranteed, thus ensuring to every person the status of a full-fledged member of society. With the growing role of digital technologies, including the internet, in exercising the fundamental rights of a person, the digital divide is discussed more often. It is caused by different possibilities for persons to access the internet. The digital divide is caused not only by the fact that part of society lacks resources for ensuring a computer or the internet connection, it is also influenced by a person's age, gender, internet literacy, and other circumstances. Hence, if the right to access internet were recognized as being a fundamental right, this divide could be decreased, thus fostering equality and inclusive society. At least now, the state's obligation to ensure to a person access to the internet does not follow from the international law. However, already now, several states within the European legal space, and these are Greece and Portugal, have enshrined in their constitutions a person's fundamental right to the internet. Several other states, for example, France, Estonia, and Finland, although without introducing amendments to their constitutions, have recognized a person's right to the internet access. France has substantiated the recognition of this right by the fact that the internet is an important tool for exercising the freedom of speech and other fundamental rights, whereas Finland links it to the need to decrease inequality caused by digital technologies. The United Nations Special Rapporteur on the promotion and protection of the right to freedom of opinion and expression, Frank Leroux, underscored already in the report of 2011, and I quote, "Given that the internet has become an indispensable tool for realizing a range of human rights, combating inequality, and accelerating development, ensuring universal access to the internet should be a priority for all states." End of quote. In this report, states are called upon to implement all necessary measures to ensure in a meaningful way access to the internet to every person, also by including updating of digital competences in education programs. Similarly, also the report by the Organisation for Security and Cooperation in Europe of 2012 underscored that everyone should have a right to participate in the information society, and states have a responsibility to ensure to everyone access to the internet. Whereas in 2016, the United Nations General Assembly adopted the resolution calling upon the states to use a human rights-based approach in providing access to the internet. Several conclusions follow from this. Firstly, the right to the internet access is an important tool in exercising other fundamental rights. Secondly, the state also has the obligation to introduce the necessary measures for ensuring access to the internet. However, does it mean that the right to the internet should be considered as being a person's fundamental right? And if so, should it be deemed to be a new fundamental right? Or is it only an element in specifying the already existing fundamental rights? It has been argued that there is no need to envisage a new right to the internet access, since this fundamental right already exists, and this to be derived from Article 19 of the International Covenant on Civil and Political Rights, which provides that everyone has the right to hold opinion without interference, and the right to freedom of expression. Namely, the future development of technologies had been taken into consideration while drafting this international document. However, this does not mean that the right to the internet access is considered to be an independent fundamental right. Rather, the internet is linked to classical fundamental rights, most often to the right to the freedom of speech, the principle of legal equality, or the principle of the protection of human dignity, considering it a form of exercising these fundamental rights. Also, the European Court of Human Rights in its case law has examined the internet access in connection with the right to freedom of expression defined in Article 10 of the European Convention for the Protection of Human Rights. The Court has noted that although Article 10 of the Convention does not impose an obligation upon the state to ensure the internet access to everyone, nevertheless, the internet plays an important role in exercising the right to receive information included in this article. The Latvian Constitutional Court, in a case related to the prohibition for a convicted person to use a computer to continue studies for acquiring higher education, has noted that a computer with internet connection may be recognized as being an instrument for exercising a person's fundamental right to education. Namely, the court concluded that the possibility to use a computer as well as internet access was a way in which actually the right to education was exercised. Several arguments have been used to validate the opinion that a new fundamental right of the internet access is not necessary, because it's mentioned that internet, as to its meaning and nature, cannot be the object of fundamental rights, but is only a tool for exercising other rights, for example, the right to freedom of speech. It is also contended that the right to the internet access does not have such value as to be recognized as being a person's fundamental right. One of the internet fathers, Vincent Gray Cerf, also has expressed his opinion regarding a person's right to access the internet. In his opinion, technologies may serve to ensure fundamental rights, but as such they cannot be an object of fundamental rights. It is a mistake to grant to any technology, also the internet, such value that would allow it gaining the status of fundamental rights. He compared the internet to a horse, arguing that previously, to lead a proper life, it was important that a person owned a horse. However, this did not mean that a person had the right to a horse. On the contrary, a person had the right to a life worthy of human dignity, and the horse, among other things, served to ensure it. Likewise, it has been also argued that such new fundamental right is not necessary because its content is not sufficiently clear. Moreover, in practice, it might be impossible to ensure this right due to economic considerations. However, an opinion to the contrary also has been expressed, namely that the content of fundamental rights is shaped also by the measures that facilitate exercise of this right. And we previously concluded that the internet is a tool. And now this argument that these tools could facilitate exercise of these rights. Digitization of society, economy, politics, and culture proves that the internet is not a temporary phenomenon, but rather a contemporary reality playing an important role in exercising fundamental human rights. Moreover, the internet offers significantly broader possibilities, and it cannot be compared to other means of communication. However, the need for such new fundamental right is mainly substantiated by the fact that in the digital age, there are numerous fundamental rights that cannot be exercised in full scope unless access to the internet is ensured. The right to access the internet is important in decreasing inequality caused by the digital divide, thus ensuring protection of human dignity. Only if access to the internet is ensured, everyone's sense of being needed by their state, of being able to realize one's creative potential, adopt decisions, and participate fully in the life of the state and society is being fostered. It's probably self-evident that any discussions regarding the need for new fundamental rights focus on human dignity, because human dignity and the value of each individual is the core of fundamental rights. Namely, all fundamental rights are built upon human dignity. In specifying the principle of human dignity, The Constitutional Court has recognized that human dignity is a constitutional value of Latvia, an independent and democratic state governed by the rule of law, which is unconditionally vested in each human being, and the state is obliged to ensure to everyone the possibility to create such life that is worthy of human dignity. A democratic state governed by the rule of law must ensure that each inhabitant has incentives to become involved in the life of society and the state.
However, the specification of the principle of human dignity is constantly influenced by the changing real-life development of society and digital technologies. If the principle of protection of fundamental human rights included in the Satversme is no longer able to ensure protection of human dignity, then there are grounds to believe that a new fundamental right is needed. In other words, if the state's obligation to ensure the internet access cannot be derived by specifying the content of fundamental rights, which are already included in the Constitution, then to protect the human dignity, a new fundamental right or rights envisaging a person's right to access the internet are necessary. Constitutional Court has already encouraged legislature to think about the legal relationship between the society and the technology, which renders the laws outdated or obsolete, and rights need to be reviewed, and legislature and other government branches that are responsible for the lawmaking should also keep adrift of the social progress and the needs of the society that are driven by the technological advancement, and should find a constitutional solution to these new interactions or relations. This is what the paragraph 4 of the preamble of Satversme says, where it indicates that Latvia, as a democratic country, adhering to the rule of law, respects all human beings and freedoms and will protect the fundamental freedoms. At the same time, if access to internet would be a fundamental right, it would be quite challenging to provide or specify the scope of these rights. Of course, these rights come with an obligation to ensure the accessibility of computers and networks, especially for those who have no access or have no means to acquire such infrastructure. But we must also remember that right to access internet does not mean that you are only entitled to access the relevant infrastructure to go online, but this would mean a real access to the internet, which again boils down to the digital skills of the population, the ability to use the opportunities that the internet provides and how to use them safely, for example, the ability to critically assess, filter, evaluate information, navigate in the information space, and also be resilient towards misinformation. These skills across all levels of education system should lead to a fairer, more inclusive society. And the question about the obligation of the state to ensure unlimited access to internet is also very challenging. Democracy, sustainability, respect for human rights and fundamental freedoms are overlapping and complementary values. One of the key principles here is that a person can exercise his or her or their rights according to the essential goals of these rights and the purpose. You cannot use your human rights to restrict the rights of others or undermine democracy. However, internet or online environment gives you unlimited opportunities to interact with others, and it also gives an opportunity to balance contradicting values and competing ideas. For example, the abuse of the freedom of speech may lead to hate speech, or, for example, infringement of the privacy or other fundamental rights described in the Constitution. Internet can also be used as means of manipulating the public opinion and thus undermining the values underpinning a democratic system. So the rights to access internet and online content require us to find balanced solutions on how for reducing the potential risks. In conclusion, the respect for human rights, which are essential to the human rights, should respect the technological development. State has the obligation to provide the access to internet if it cannot be derived from the existing basic rights that are described in the Constitution and other laws. Then we must find new ways to regulate these rights or introduce new rights, such as access to internet. And the best way to achieve that is by ensuring a person's rights to access by making the amendments to the Constitution. Thank you. Thank you, Madam Kocinia, for the interesting presentation.
I found it very interesting that Judge Zemel and Judge Kucina had a common touching ground in terms of the need to review the existing regulation of fundamental rights, what you call as a stress test, and what Judge Kucina referred to as the need to periodically review whether the existing regulation of fundamental rights is still appropriate to the current day requirements. And it seems like the answer given by Judge Kucina is that a person has a right to a horse and a right to learn how to use the horse and to use the horse usefully for all purposes. And maybe that is also the answer to the possible domination by tech giants that was mentioned by the previous speaker. I'm sorry, Ms. Torgeisdottir. Thank you very much, all three main speakers. This was each speech was approaching the topic of today's panel from a slightly different angle, but ended up landing on the same fundamental issues. So it was interesting that the field was covered from various angles. The next speaker, who I would like to ask to reflect upon what has been said during this panel, is Mr. Heiki Lot, a judge of the Estonian Supreme Court. And he's a member of not only administrative cases chamber, but also the constitutional review chamber. And previously he has held various political positions in the Estonian political establishment. We would like to hear your thoughts on today's topic. Thank you very much.
Thank you. Good afternoon. First, I have to make a correction. I have not held any political position. Not in this life on that earth. I have been active serving the government for many years, for 15 years as a non-politician. And I have seen a lot of politicians, how they act, how they think, what they do, and when they will do and deliver something. So I know about the not the politics, but about the government and how politicians are governing the state. And I think this is a sort of asset when I'm in my present position, especially being a member of the Constitutional Law Review Chamber in the Supreme Court of Estonia. We do not have a specialized court or a specialized constitutional court. So we have a sort of one court which embraces at least 3 different courts. So one of them is the Constitutional Law or Constitutional Review Court. Coming to the subject of this afternoon, first, thank you very much, speakers, for your interesting and thought-provoking presentations, and of course, congratulations to Latvia on the centenary of the Constitution, as well as the 25th anniversary of the Constitutional Court. I know the celebrations were planned for December already last year, but we seem all to be victims of this cursed coronavirus or COVID pandemic. Judge Ms. Irena Kutsina summarized in an excellent manner arguments for and against the right to internet. Estonia is sometimes considered a country where technology is widely used. We do not invent technology. We try to use technology as much as possible. And it was, for me, very interesting to hear how well you put the arguments in favor and against the special right or the special fundamental right to internet. And as to the taking positions between the optimistic view and a more pessimistic or gloomy, as you said, view, as we have a need to modernize our framework, constitutional framework, international framework of fundamental rights. I think a lot has been said, and I must admit I would be in a quite difficult position, because when I thought to give you some reflections based on my country's experience, I would say that my position tends to be rather to be an advocate of one certain position rather than to be a judge right now, as you asked me to be. This year, my country is celebrating the 30th anniversary of the Constitution. And in this period, the Constitution has been amended 5 times. Within 30 years, 5 times. The second chapter of the Constitution on the fundamental rights and freedoms has remained untouched since its adoption in 1992. However, from time to time, we see a revival of debates over amending the Constitution in order to bring it into line with the changed circumstances, or whether its dynamic interpretation should be preferred. At least so far, the latter option has prevailed and been considered to work even in the area of modern technology, and even in the case of Estonia, where we try to use technology as much as possible. The fact that the European Convention on Human Rights served as a source of inspiration for the Estonian Constitution certainly plays a part in this, as well as the case law of the European Court of Human Rights is widely used interpreting the provisions of the Estonian Constitution. It is known that the wording of the Convention has not made its application to the changed circumstances significantly more difficult. It can be considered as the cornerstone of the Convention doctrine that the Convention is a living document. The consensus needed to change an international human rights instrument is difficult to achieve. The same can be said to the domestic constitutional framework. Moreover, constitutional amendments are not protected from being made for short-term political gain. And this is something which I have personally tested. There is a danger. And for this reason, the permanence of the constitutional has been considered a value worth protecting and an important part of constitutional culture. Last time, it was 4 years ago in 2018, when a group of constitutional law experts in Estonia proposed to supplement the catalogue of fundamental rights with some new fundamental rights. The report of experts found that although the case law on fundamental rights so far has managed to fill all the gaps in the Constitution, largely with the support of the Convention and the Charter of Fundamental Rights of the EU. The clarity and modernity of the Constitution are values in themselves that also express the constitutional culture as well. Probably inspired by the EU Charter of Fundamental Rights, the experts propose to insert a new fundamental right to the protection of personal data to the Estonian Constitution. Until now, it has been protected through the fundamental right to privacy. The experts also propose to replace the present right to confidentiality of messages sent or received by post, telegraph, telephone, or other commonly used means with a more general right to confidentiality of communication. It was meant to protect more effectively the metadata of communication, like communication facts, which until now has been considered to be a part of the protection of privacy. And please note that mentioning of word telegraph in the Constitution was not an issue at all. However, it is doubtful whether in a complex world the modification and reclassification of existing fundamental rights will contribute to legal clarity. In the plurality of legal systems where the same values are protected by at least 3 sets of norms, domestic, EU, and international, it is perhaps naive to hope that implementation problems will disappear when these sets of norms are changed. Therefore, a need to create so-called new fundamental rights should be viewed with some caution. Upon closer look, they may turn out to be only a specification of the so-called old fundamental rights or a precondition or means for their realization. This especially seems to apply to such a right as the right to the Internet. The Internet, or more precisely a functioning Internet connection, is first of all a means through which it is possible to realize or exercise other fundamental rights. For example, the right to information, the right to education, the right to go to court, or the right to vote as well. As we have e-voting in Estonia already for many years, even we can say for decades. Apparently, no one wants to protect one of the many communication methods as such at the level of the Constitution. Even in the area before modern technologies, we did not ask whether the Constitution should include the right to a pen, paper, or printing press, without which the exercise of fundamental rights would not be possible. Thus, it seems that what we are talking about when we talk about the right to the Internet is rather the right not to be deprived of the rights guaranteed by the Constitution to the lack of access to the Internet, or the right that the realization of fundamental rights without the help of the Internet would not be excessively complicated. So that was my position, not as a judge, I happen to be, but as a lawyer advocating one of the positions. And as you could also see, it comes from the country where we try to be very ahead of using technology. The lawyers seem to be quite on earth in this issue. Thank you.
Thank you very much, Judge Lott, for doing both things, for giving a slight response to the main speakers and for giving us a perspective of the Estonian situation. And I apologize for having placed you in a political office. It was unintentional. It's also interesting that Judge Lott explained the presence of the word telegraph in Estonian constitution by referring to the holistic approach to human rights, where three instruments protect the same right, then there is no need to amend the Estonian constitution. Our last respondent is Judge Andrei Abramovich from the Constitutional Court of the Republic of Croatia. Welcome. Judge Abramovich has been a judge for longer than Latvian Constitutional Court has existed, so he's indeed an extremely experienced judge, and he has been a judge of the Croatian Constitutional Court for 6 years, since 2016. We would very much like to hear your perspective on today's panel's topic. Thank you very much.
Thank you very much. Let me start by congratulating our hosts on their anniversary, and by thanking our host for inviting us. Esteemed colleagues, I prepared a short, very short, less than 5 minute short case study on a ban of Russia Today on internet that is recent, and that is, I thought it would be interesting. But 5 minutes is not enough for that. So I will try to merge a very, very profound my predecessors on this place, and very few of my thoughts on that particular topic that I think goes together. Mrs. Zimele, Professor Zimele, raised the eternal question of axiology. What's good, divide good and bad. What is good, what is bad? That is a really eternal question, and goes with our profession as judges, and goes with that particular case of that ban. Can we tell good from bad instantly? Mrs. Torgelsdottir, she raised the question of what the internet is in its wholeness. So, what is internet? On my mind, arrived one idea of maybe the most famous theoretic of media, Marshall McLuhan, who said, media is the message. So if the media is the message of internet is that is all on internet. Everything is good and bad, useful and useless. And Mrs. Kucina, Professor Kucina, yes, Judge Kucina, raised the question of right to internet as a right to complete information, to everything. So, for me, it was surprising when I found that in China, some internet giants are not available. Access to it is not available. And in that sense, we thought that in European Union it is not possible. So that ban on Russia Today was some kind of surprising for me, and I think that that ban is not good. The General Court of European Union treated that like from the aspect of freedom of speech and freedom to express and freedom to conduct the business. But I have in mind a different approach. Right for citizen to be informed and to make his own political decisions, because that ban was initially adopted by the Council, and Council is political body, so that goes and has the connection mainly with the politics. We must have faith in the voter, in the citizen. Voter, citizen, is a cornerstone of the democracy as a system. If the voter, not citizen is the voter, if citizen cannot divide good from bad, if citizen cannot tell what is true and what is not, then democracy as a system has a very gloomy future. So we must educate our citizens. We must risk, even a risk, in that large forest that internet is, that they will find a right path, right way, and make good and right choices in the end. That is not question of solidarity. That is not question about victims. We know everybody who they are. Solidarity is not only welcomed, it is necessary. But I don't think that information blockade is the right way to deal with the conflict. For conclusion of that really brief speech, because my 5 minutes expired, I'd like to say, experience has been teaching us that after major, even centuries-long European conflicts, there is a period of peace and close international cooperation. The experience of the particular conflict reveals that even between the countries officially in the conflict, there is a albeit limited, movement of goods and people. If people can travel, if goods can be transported, then the information must be able to circulate as well. We had the war ourselves about 30 years ago, and we maybe know the best that after the war there is a peace and there is a future for both or several parties that were in conflict. So we must be able to believe that, and we hope so, of course, that the present conflict will be soon ended, and we all can live in a better future and in the democratic system. I couldn't read my speech. I tried to improvise it, so I must apologize for the mistakes I made in my language. Thank you very much.
Thank you very much, Judge Abramovich, for your perspective and for being responsive to the speeches that were given by the main speakers. And I found your optimism inspiring because unlike, I think, what I heard from Judge Koskelo and Judge Kuch this morning, who were speaking about with incredulity about people who can't tell truth and false part, Judge Abramovich seemed to put a great trust into ability of voters to distinguish between these two things. And I think perhaps there is a conceptual difference between these approaches, and I think that's sort of one of the fronts that we have been trying to resolve during these discussions. Thank you very much again, all speakers and all discussants for taking part in today's panel. It was a great pleasure for me to be able to introduce you. And now I would like to give floor to President of the Constitutional Court, Aldis Slaviņš.
Thank you, but as far as I understand, we have a couple of minutes for questions. Yes. First of all, thanks a lot to all three keynote speakers for extremely interesting presentations. I would completely agree what kind of evaluation gave our Estonian colleague. Thought-provoking presentations, and it gave me base to ask small questions to all of you, three. Short questions. My esteemed colleague Ineta, I would ask to you such kind of question. You referred to one constitutional court ruling issued in 2007 about rights to submit not constitutional complaint, but complaint to the Constitutional Court by NGOs. And you evaluated it as some sort of some sort of example how Constitutional Court could act in the way how to ensure sustainability. Absolutely. So it means, in my understanding, my colleagues at that time, they could look into future. Yes, and now I am come to my question. If it is necessary for the sustainability to have this ability to look into future, could you give some hints? How? Not. Yeah, but hints about the competence of constitutional courts. I see there is a quite tiny base to breach competence of constitutional court competence, let's say. If we are so active in this field to look how our decision will affect future after 10 years, we are trying to modulate what would be the best solution. And we are not going to say what is provided by the law, by the Constitution right now. So, and could you give some hints how be sustainable on the one hand, but on the other hand, to be within competence border of Constitutional Court? This is question for you, for my colleague from Venice Commission. You said that just a few companies controls internet, online world, let's say. And as a one solution, you said we, Venice Commission is intended, or it would be right way to break up monopoly of those few private companies who control internet. My question is, since there is no agreement across whole European nations about the question that internet is a fundamental right, what is the base for such intention to break up monopoly of those few private companies? And for my esteemed colleague and Vice President of Constitutional Court, you said that from your point of view, in our Constitution should be made amendments in order to provide right to internet. Don't you think that it would be another excellent example if Constitutional Court would recognize in our jurisprudence that our Constitution has already provided such a right, and if you agree that this would be an excellent example of way how Constitutional Court acts in sustainable way, in which article of our Constitution, or maybe a couple of articles, you would see our Constitution, which is still modern, as we underlined a couple of times during these days, is provided. Thanks a lot.
I suppose we have another 2 hours, right? Very quickly. I will try to be very brief, although I was trying to give you the elements, actually. Now, in a nutshell, in the Latvian Constitution, I take just that example, in the Latvian Constitution, we already have the principle of sustainability, sustainable development of Latvian people. It is in the introduction, and also it's the whole purpose of Article 2. That general principle of law is material in scope, materiālais princips. What it means is that basically, in many cases, and hopefully practicing lawyers think about it, you can have an argument that goes, well, whatever, you have a human right, but it is also argued that because of a sustainable development principle or sustainability principle, we are arguing that, you know, in this case, internet should have been provided. That's the example, exactly that example. Now, you already know, according to the methodology of the court, you can take the principle of sustainability into your motivation, either when assessing what choice legislator has made, you can do that already now, or, as I mentioned, I gave you also the example when assessing the legitimate aim. Is the legitimate aim according to that paradigm of sustainability? It's already now, you can do it. And also when you assess alternatives, you know, whether the restriction on a right, for example, to access the internet is a right restriction, for example. It is part of the Constitution as we speak. Now, that's the material side to it. The complicated thing is, and that's what I said, when it comes to actio popularis, and that's where the 2007 choice of the Constitutional Court at that time, well, you can say it was visionary, but it certainly was absolutely motivated, and I could side with it at that time and now, because it extrapolated from Aarhus Convention the idea that you have to have effective remedies to protect environment. Now, how do you ensure effective remedies? By access to court, whether it's Constitutional Court or Administrative Court. Now, that is the thinking. Now, I do recognize that the way I have put it is probably slightly simplistic, because of course we have lived, you know, the whole 20th century is about to avoid actio popularis, whatever that means. So this is why I suggest
that what is imperative now, if we are in sustainable development paradigm, and Europe should be, then we should really have a very serious reflection or reassessment and inventory done of what we mean by actio popularis, really. It is this that is your concern, because the only limit would be, that we should not open a Pandora box. And that's what we need to redefine now. Because the fact of the matter is, I take again environment, everyone, every citizen of the world is interested to avoid climate change. Now, that is what we should be discussing. Does that mean constitutional courts have no role to play? I doubt it.
Thank you very much for these interesting questions. You asked what is the basis for breaking up monopoly. I am talking on behalf or on the basis of the European Convention on Human Rights, where you have Article 1, where the states, member states, are under obligation to guarantee to everyone within their jurisdiction the rights in the Convention. There is a property right, of course, and this property right conflicts with the Article 10 right. The right to freedom of expression, the right to a free internet. However, a medium like the internet, where online and offline rights apply, where the Convention applies to the internet, this has been confirmed by the Council of Europe and the Council of Europe bodies. In the Delphi case versus Estonia, the internet was defined as the public sphere, where there are obligations. So the internet is not protected for the sake of the property of Max Zuckerberg or whatever his name is. The internet is protected for the role it has to play in the world. And if we see that human rights are seriously threatened, there is legislation on data protection. And why not? In the traditional media environment, there was huge, enormous concentration, and there was talk of legislating to break up monopolies in the traditional environment. So the same applies for the internet. This is getting extremely serious. We do not want a world that is ruled by oligarchs. We aim for democracy, human rights, and rule of law. It may not be practical, it may not be practicable even, but we must still aim for it, and we cannot just stop and give up and say this is private property. I know that the US Supreme Court in 2019 denied to grant the internet the status of similar to a government agency or a public service status, really. But still, there is a part of the Federal Communication Act that applies to the internet, and they must adhere to. So this is still confusing. We cannot just simply say that the internet is the property of someone and it's affecting the whole world, it's affecting everyone. And as Ineta mentioned in her excellent speech, we live in a new global community where duties of each and every individual matter, and we can just not stand aside and say that this is just something that we cannot interfere with. So we have to start somewhere, and this is where the Venice Commission is supporting the Parliamentary Assembly of the Council of Europe.
Paldies,
Thank you, Mr. President, for your question. I suppose that those who were listening to the pros and cons that were presented, we have an excellent example from Estonia, which in a digital development sense is far ahead of us and will continue to be ahead of the curve in this respect. We see that Estonia, or a representative of Estonia, a lawyer of Estonia, a judge from Estonia, thinks that we don't need the right to internet as a separate right. It is okay if we interpret it on the basis of the existing fundamental rights. And again, going back to this comparison with a horse, do we want to own the horse, just merely own the horse? And that is how we will achieve dignity and will be able to enjoy our fundamental rights, like a right to education, right to voting rights, and so on and so forth. That is up to you to decide. But as far as Constitutional Court is concerned, or the Satversme Court in the case of Latvia is concerned, the answer is yes, Constitution is a living organism. It continues to evolve, develop, it's dynamic, it continues to progress according to the spirit of the times, and it needs to be applied in modern conditions, in modern context, and we already see several judgments coming out of the Constitutional Court. I will not mention those that I already mentioned in my presentation, but let me refer to one of the more recent rulings regarding remote learning during the pandemic. And I'm talking about school children, about the pupils. And in the opinion of the Constitutional Court of Latvia, the right to work remotely or learn remotely, or the right to distance learning, involves the access to internet, or the right to access the internet, which means that you need some resources to ensure that, and the court basically assessed whether the state has provided the necessary means or resources for these rights to be properly exercised. So, in other words, for these rights to be applied and fully respected. And in its assessment, the court indicated that the state or the government has provided pupil with the access to internet. Their right to access to internet has not been breached. So there is a specific case law. The Latvian Constitutional Court has decided that it is your right to access online learning, and the same applies to online voting. Online voting may also end up in a constitutional court, because this is all linked to the digital divide. Not everyone that has access to internet can go online, so we must carefully balance the right to access the internet with the right to vote. So these are future challenges that the Constitutional Court will probably have to sort out. So, in principle, if we want to create new fundamental rights, there has to be the support in the society, and the society must accept that if these rights do not exist, we need to invent ones.
Equitably distributed questions, and thank you very much for the panelists for their exhaustive responses. Unfortunately, it seems if we went on longer, then this would be inhuman and degrading treatment of our translators. Therefore, I will give floor to Judge Laviņš to close today's discussions.
It is briefly past 5. We've been working since 9 o'clock in the morning. It's been a tough day, a long day, and we are, I suppose, a bit tired. I thought that after lunch it will be difficult for us to sort of get swinging, but, unfortunately I was absolutely wrong. We had so many exciting speeches that, kept me thrilled throughout the day, and I would like to sincerely thank all of the speakers in this panel discussion, everyone who contributed to the second panel discussion and also to the first panel discussion. Thank you. Big thank you to all the speakers and both moderators of both sessions. So thank you very much. Thank you all for being actively involved. We'll continue, or we'll close the conference with the third panel discussion. I would like to wish everyone, I suppose, a wonderful afternoon. Enjoy your evening. Thank you. This concludes the first day of the conference.
We can just leave.